Audience side, audience side. I was taking a lordship's kind leave with Honorable Justice Sain's leave. I was mentioning this assigned matter. This was heard by your lordship on 3rd July. Lordship directed the parties to exchange affidavits and
We will be sitting in the, most probably in the next week with Justice Chatterjee.
my lord.
When we sit, you mention.
Well, let it be listed any day.
That day cannot be listed. You come and mention.
My lord.
Are you mentioning
Upon notice? Upon notice.
Today you are mentioning.
Mentioning upon notice, yes.
Who is your other side?
But on the other side, Mr. Anindya Mitra was appearing for one of the parties, and Mr. Alok Ghosh was appearing for the KMC. But I put them on notice. I'm mentioning upon notice.
No,
But affidavits are exchanged, my lord. Lordship directed, my lord.
Original side.
The lordship directed on the earlier question to hand over to your lordship, my lord, the copy of the writ petition. That has been done. That is there.
I understand. We have fixed a date for hearing of a matter.
My lord.
Which has to be finished first.
My
because
lord.
We have heard
My
that.
lord.
So please remind us on the day we sit with a notice.
I'll come back.
Get the list, original side list. On that day you remind, we shall.
Grateful.
May I comment to mention one matter for inclusion, your lordship? It was heard, your lordship, before the vacation. Thereafter, it was supposed to come up after the vacation. It has not come up.
Is it motion stage?
Yes, your lordship.
Hand over.
Lordship, yesterday, Lordship, directions were passed for affidavits and Lordship for hearing. Lordship, in that matter, Lordship, the applications both has been disposed of. So, Lordship, there is no application pending. Only the appeal is pending. Yesterday, my lord passed the direction for affidavits and fixed the matter for hearing.
Yes.
Applications have been disposed of.
Maybe, but the records are there.
Records are there.
So when application was not for dispensation of paper book, that will be there.
Yes.
When we just take care of short hearing on document, all records are there, so there won't be any problem.
I thought there might be. That's why, Lordship, I was mentioning that it has been disposed of. Applications in which affidavits have been directed.
যেটা disposed of application সেটা কি নামিয়ে তো দাও না, ওটা তো don't think that will be a problem. You argue on merits, we will take note of.
Lord, may I permit contempt application inclusion of the list?
Fresh contempt?
Yes, Lordship.
Before which bench?
Lordship,
Justice Chatterjee,
yes,
you mentioned next week. His Lordship.
May I have a Lord's kind leave to mention a matter for inclusion in the list? This is an appeal arising out of a writ, service writ. The application for condemnation.
Appeal of which year?
The appeal of 2024.
It has been fixed for here.
No. I'm seeking for inclusion in the list. The urgency being the respondent before my lords have filed a contempt application. Contempt of non-compliance of the order passed by the writ court.
At the motion stage, what was said?
No, at the motion stage, the application for condonation of delay was allowed, and the matter was fixed to thereafter appear after the vacations.
Yes,
and that since the bench has changed, the matter has not appeared. That may be so. Maybe may a lord's pleasure to keep it on a Wednesday.
No, date cannot be fixed. Keep a watch on the list.
May I have your lordship's leave to mention a matter, but to mention an appeal, without any connected application. But here, I'm an auction purchaser. I had preferred an appeal way back in 2015. But there was a reference to a larger bench on an issue of law, which has subsequently been covered by a judgment of the Supreme Court. So,
is it a tribunal application or mandamus appeal?
It's a mandamus appeal. It's an appeal from a writ petition. Auction purchaser, I have not been given possession of the property that I have purchased.
What happened?
But the larger bench was constituted. That reference is over because the issue is covered by a judgment on the Supreme Court. It is recorded in the larger bench decision, in the larger bench order. So the appeal has been directed to be listed before the regular bench. But that happened way back in 2019. But that is why I'm mentioning.
What happened from 19? You have not mentioned.
But thereafter nothing happened. The bank has still not given me possession.
Are you mentioning upon notice?
Yes, I'm mentioning upon notice on all the parties. The bank is a party. But I have given.
What is the stage of the proceeding? It was pending, kept pending.
Yes, it was kept pending, and on that issue of law, it was referred to the larger bench. And the larger bench has since decided the issue. My lord, I'm grateful, my lord. I'm handing over the notice, my lord. The slip is coming, my lord. I shall hand it over to. I'm grateful, my lord.
My lord. He বলছে নোটিশ দিয়েছে তো
Lord, may I have a lordship indulgence to mention one matter? This is, my lord, which is a service matter, hearing. All right,
are you mentioning upon notice?
No, my lord.
Please give a notice and mention. Yes. Call the list.
I'm for appellant. My lord, Mr. Animal Mitra is appeal on behalf of the respondent, my lord. Union of India, my lord.
The instant appeal is dismissed.
এই শোনো, এটা সাহায্য তুমি এখনই করবে। Yes, call the next.
Dismissed.
Lordship, I am for the appellant in this matter, Lordship. This is an appeal against the judgment and order dated November 27, 2019, passed by the Railway Claims Tribunal, Lordship. On the last occasion, Lordship, your Lordship passed the direction to find out the appropriate bench, Lordship. That is courtroom number 33, Honorable Justice Ananya Bandhapadhyay have the determination all claims tribunal, Lordship.
It will deal with claims.
Determination আছে
হ্যাঁ
পুরো determination
হ্যাঁ
হ্যাঁ ওই কথাগুলো বলছেন রিলিজ হবে
as the present appeal arises
Three, my lord, I beg to appear on behalf of the petitioner, my lord.
I beg to represent the state respondent.
This is, my lord, with regard to the termination of Borgadarship, my lord. The petitioner is the right before your lordship.
Come closer to the microphone or adjust the microphone.
Lordship. This is, my lord, the termination of Borgadarship, my lord. The right is the petitioner before your lordship. Now the application was filed. Initial application was made, my lord, under section 18(1) of the Land Reforms Act. and the initial order was passed on 24th of January 2018. Your Lordship, kindly have a look to page 20 first. This is the initial order from which, my lord, the cause of action has started. Annexure P2, my lord, the order dated 24th of January 2018. The learned BLRO has found that the Borgadar was defaulted in supply of the proceed
Order
of
under section 18.
18.1.
Is it an appealable one?
Yes, this tribunal, my lord, the tribunal of this of passed the order, impugned order, challenging that order, my lord, I have come before your lordship.
No, your order under challenging the
Yes, that is
the SAT was it an appealable order? Order was
that
passed
was
under
yes,
section 18.
yes.
Appealable before whom?
Appealable before, my lord, the SDO.
So then why did you file the
No, thereafter, my lord, this is the initial. This is the
SDO passed an order?
No, this is the BLRO passed the order. Nobody challenged that order. But what happened, my lord, by this order, the learned BLRO has
Terminated.
not terminated,
No, BLR has not
directed to pay the amount in 3 installments to the Borgadar. Now, Borgadar paid 1 installment.
Value for this
Yes, crops, crop value equivalent to the crops. Now, out of 3, 1 has been paid. Now, 2 defaulted. So there was a clause in this order that if he failed to pay the amount, then this order can be executable. That is why the next application was made by the petitioner. Your lordship, kindly have a look to the application thereafter.
Page 27.
Page 22, P3.
No, sir. Prior to that, come to page number 21. What does it say?
21, your lordship, kindly see.
Present today.
Yes, after calculation.
Being considerable, it is ordered that the Borgadar is allowed 3 installments.
Correct.
Ending on such and such. The prayer of the applicant is therefore allowed.
Yes.
And the Borgadar is directed to repay the amount as determined in such and such installment.
And 3 installment date has been fixed and amount has been fixed. If your lordship kindly sees the table. Now, your lordship kindly sees next paragraph. Let a plain copy of such and such. The Borgadar is directed to pay the amount.
Have you completed service upon the private
Yes.
respondent?
Oh, I'm sorry, my lord. In each and every process, the private respondents were served. Somewhere they have appeared, but did not comply the order. In each and every proceeding. Now, your lordship kindly sees there is a executable clause has been there in 24th of January 2018.
Yes.
Now, your lordship kindly sees there.
Representing the riot or the
Riot petition. Now, my lord, in view of that order passed on 24th of January, the riot, my lord, file an application before the learned BLRO. If your lordship kindly sees annexure P3.
Sir.
Your lordship. I'm sorry.
Page number 21. What is the last portion of
last portion of the order? If your lordship kindly sees, the Borgadar is directed to pay the amount as determined herein above to the petitioner by the scheduled date, failing which the applicant will be at liberty to apply for execution of this order before the appropriate authority. This case is thus disposed of.
Execution of this order means payment of money.
This is the order. Execution, your lordship, I will show from the Land Reforms Act. If the Borgadar failed to pay the amount, then the termination of Borgadarship is there. Provision is there.
What is page 27? You executed
20
execution case.
Yes.
Started
Now 22 is my application. If your lordship kindly sees, my application start from page 22. That is before the BLRO.
Come to page 27 now.
27 is the order.
9th of October.
Now, before that, my lord, I made the application before the BLRO. Now, BLRO by the letter prior to that page 26, transferred the execution case to the SDU. I made the initial application before the BLRO for execution. Because your lordship knows the execution.
What happened, sir? Tell us.
That has been transferred to the SDO for execution. Now, your lordship kindly sees that.
What is page 27?
27 is the final order whereby the learned SDO, your lordship kindly see the last portion of the order, finding himself the Borgadar as the defaulter in payment of the due 2 installments, the learned SDO has passed this order.
Person.
The last portion, I'm not going into the total entirety.
You are reading which portion, sir?
Page 28, the
Page 20.
20.
Yes. Yes.
At this stage, BLRO Pandua block is directed to terminate the right of cultivation of the above scheduled agricultural land by terminating the Borgadarship of the above named recorded Borgadars and delete the name of the said Borgadars, maintaining all legal formalities as per provision of West Bengal Land Reforms Act 55.
Then what happened?
Now, after this, I again went before the BLRO for execution of the order. Your lordship kindly see the next page, annexure P6, page 29. Now, since the learned BLRO is not proceeding, I filed that one application for expeditious disposal before the learned tribunal, West Bengal Land Reforms Tribunal.
The annexure P6, what prayer you have made?
Annexure P6, page 29. This is the application for execution of SDO order. This has been made to the BLRO. If your lordship kindly have a look to the heading. Now, for expedite the hearing, Lord, I file an application before the learned tribunal. And after that, we have also challenged, since the tribunal also delaying the process, we have come before your lordship. Your lordship kindly have a look to the order passed by your honor. Annexure P8, page 40. Page 40, my lord, I'm showing the relevant paragraph, page 41, starts from very bottom paragraph, my lord. In view thereof, the learned tribunal, has your lordship gotten? In view thereof, the learned tribunal is requested to take up the matter for hearing on the date fixed on such and to dispose of the same as expeditiously as possible, preferably within a period of 4 weeks from the said date, without granting any unnecessary adjournment to the parties. The state respondent shall produce the status report as filed today before the learned tribunal on the date fixed on 27th January 2022. So the state respondent has filed a status report before your lordship. Your lordship did not consider it since the learned tribunal was in session of the matter. Now, before the learned tribunal, the state has filed the report. I have annexed that report. That is very German. Your lordship,
what has happened? What has the tribunal ultimately said?
Ultimately, your lordship kindly sees the page 45 is the report, status report. Learned tribunal found that page 47, relevant page 47, bottom portion.
Internal page?
47, internal page 5. The state government appointed all subdivisional officer as executing officer in respective subdivisional jurisdiction.
This is a status report.
This is status report by the state. Again, it is to submit that even though the executing authority being the subdivisional officer has to execute the order as per Code of Civil Procedure, yet the executing authority cannot exercise the power of civil court conferred upon him under section 151 of the Code of Civil Procedure.
So which portion you are reading?
Your lordship, page 48, top. Again, it is has your lordship got? Again, it is to submit that even though the executing authority being the subdivisional officer has to execute the order as per Code of Civil Procedure, yet the executing authority cannot exercise the power of civil court conferred upon him under section 151 Code of Civil Procedure. It is also respectfully submitted that the executing authority cannot give order for termination of cultivation by Borgadar, that whether a person is and will remain Borgadar in a subject plot of land is to be determined by the Bhag of Charge Officer under section 18(1) of West Bengal Land Reforms Act and under section 17 of the West Bengal Land Reforms. This is contrary to the proceeding, the act itself. the learned BLRO, I applied for the execution of the order, which has been passed initial 24th of January. Now that BLRO transferred that execution part to the SDO. Now when the SDO passed the order of termination of the Borgadarship, now BLRO stated this. Thereafter, the learned tribunal has passed the order in some other point of view. Your Lordship kindly sees the impugned order now. Page 5. Milord, the internal page 5.
What
Impugned.
is the present status?
Present status, my application has been dismissed.
No. The same persons are
Yes,
continuing as Borgadar.
yes.
Yes, Mr. Galib.
Lordship, the issue is very simple. My lord, issue is, my lord.
How many times he will go from door to door?
No, he is, my lord. My lord, it is pure question of law. 118(1) proceeding was initiated by him. That a Borgadar, I am the Rayat. Borgadar is not giving me the delivery, the produce. BLRO, section 18(1) authority. My lord, what are the powers he has been given? 3 powers here, Lordship. 3 powers he has been given under section 18. What are the 3 powers?
No, you tell us what will be the solution. A person is
solution-
having a valid order of a competent
No, well, Lordship, kindly appreciates one thing.
SDO's order.
Is without jurisdiction.
Who says that? You.
No.
You being an BLRO will say SDO has passed without jurisdiction order.
No, my lord, if the order...
Sir, it is surprising.
No.
He is your superior officer. How can he say sit in appeal over the SDO's
No, but
order?
his report, which he had filed before your lordship, is in 1 WPLRT. That report was brought on record before the learned tribunal. Learned tribunal has examined the report, heard the parties, and now learned tribunal has given its observation, its own observation. It has not acted mechanically, my lord, on the status report filed by the BLLRO. Because it says that power of termination of Bargadar is vested in the BLLRO, not upon the executing authority, that is SDO. Number 1. Number 2, when the BLLRO under section 18(1) proceeding, the issue before him by the Rayat was that, see, my Margadar is not giving me the produce. That was the issue. The BLRO decided what?
BLRO did not decide. He referred to SDL.
No, he decided. At page 20, he decided that you pay the money. These are the money I am finalizing in 3 installments.
Upon failure, there will be termination.
Yes.
Page
No.
21.
Page 21, he says, let a plain, last concluding part, my lord, may I specifically read out. Let a plain copy of this order be served upon the Bargadar by registered port. The Bargadar is directed to pay the amount as determined herein above in the petition to the petitioner by the scheduled dates. Failing with the applicant will be at liberty to apply for execution of this order. Now comes the execution under section 20. Section 20, my lord. So section 20, subsection 2, the execution comes.
Then he applies to the BLRO.
Yes.
That you
No.
execute the order.
No, executing authority across Bengal
Right.
is SDO.
BLRO on by a 9 July 2018 memo, page 26,
Has since executing authority.
forwarded it to the SDLRO. To the
Matter
SDO.
is there because he says that I am not the authority, I am not the executing authority.
Where it is said that the matter is therefore forwarded for execution of the so he
Under
says,
section 20, subsection 2.
so he says I cannot execute.
As because, my lord, thus
Let us understand the facts. So he said that
he is
I
not the
cannot
executing authority.
go to the SDO.
Because I am not the executing
So
authority.
very good. On the basis of that memo, he has gone to the SDO.
Now, my lord, for every Bhaksha's case, when it is decided under section 18(1), the executing authority across Bengal are the SDOs. So that's why wrongly he has approached the same person for execution of his order. That's why he has forwarded the matter as contemplated in section 20, subsection 2, that you go to the executing authority. I am not the executing authority. Now the executing authority comes at page 27. What does the executing authority kindly says, my lord, in a proceeding under
to terminate.
He says at the concluding part, page 28, at this stage, BLLRO Pandwa is directed to terminate the right of the Bargadarship. So, my lord, issue before in 18(1), there can be 3 issues decided by the Milord Bhakcha's case. I mean,
Has this order been challenged by anybody?
now he has challenged this order.
Your state, your authority has withdrawn this order. If this is an order without jurisdiction, Mr. Galib, then the SDO has to withdraw his order. Otherwise, BLRO is the next below officer. He has to act in terms of SDO's officer.
Lordship, kindly appreciate me. If Milord,
There is a hierarchy, na? SDO passes an order. Now the tribunal, I don't know what point this tribunal has taken.
Milord,
such a
tribunal,
huge
Milord,
dispute that a person is admittedly not.
no, Lordship, may I respectfully invite your Lordship, a relevant part of the Lordship, Milord, tribunal has applied its mind. Kindly seize, Milord, internal page 4.
Tribunal has
It,
proceeded in something-
it's a pure question of law that whether the executing authority can travel beyond the order which is put to him under execution. He cannot. This is a pure question of law.
What he is required to do then?
Internal page 4, Milord.
Hmm?
Learned tribunal has applied its mind. Having gone through the Milord, the paragraph, the sentence starts with having gone through the OA and supplementary affidavit with annexures including order passed by Bhakcha's officer under section 18 WBLR and order dated 9/10/2018 passed by the SDO. This is impugned order in OA. And the status report which was submitted before Honorable High Court and having gone through the provisions under Chapter 3 of the West Bengal Land Reforms Act 1995, Rule 9 of the West Bengal Land Reform Bargada Rules 1956, as it stands as per notification dated so and so, and Chapter 6 of the West Bengal Land Reforms Manual 1991, we find much force in the submission of BLLRO, Pandua made in this status report and arguments advanced by the learned GR. Within 4 corners of this case record, we do not find any order of the officer under section 81 for termination of Barga right of the private respondents in respect of the subject land. We are satisfied that SDO Shodor is executing authority in execution of an order passed by Bhakcha's officer under section 18(1). But said SDO is not empowered by law to terminate any Bargada's right or to give direction for correction of record of rights or delegate his power to execute upon BLRO going beyond the provision of CPC of the WPL Act. It is a settled law that executing authority cannot go beyond the order under execution. In the instant case, power of SDO was limited to the process of realization of area dues as price of share of crops from the private respondents for payment to the client applicants in the prayer of applicants in Bhakcha's case number 8 of 2018 in order to give effect to the order dated 24 January 2018, passed in case number 73 Pandua so and so under section 18(1) WPLR. But SDO Hooghly passed the order in Bhakcha's case 8 for evicting the Bhargadas from subject land, exceeding jurisdiction, and so we cannot pass any order in this way for implementation of the said unlawful order of the SDO. In the light of our observation, Madam so and so, who is liable to be dismissed, since we have observed the order dated 9/8/2018 passed by the Bhakcha's case is unlawful, and order is hereby set aside. Exercising our power under section 7 so and so, in the interest of justice, the applicants are at liberty to take step before the BDSDO, submitting certified copy of this order for proper execution of the order dated 24 January 2018 passed by the passed in 73 Pandua 2017 in accordance with law in Bhakcha's case number 8 as a rental. This is so, Milord, he is learned tribunal directing that you go for execution of the order which was actually passed by the BLRO regarding your, that is, Milord, at page, Milord, 21 and 20.
Mr. Galib, is it the case of the state that since the order which has been passed by the BLR is practically for payment of money, it would be a
Certainly.
be a degree for execution of the
Certainly. Only for that. Not because, Milord, if I may respectfully invite your lordship.
As if it is a money degree.
If I may respectfully invite your lordship only for once to section 18. Kindly see section 18. What is contemplated there?
And Milord, section
A
17.
minute. Section 18 says jurisdiction to decide every dispute between a Bargadar and the person whose land he cultivates in respect of any of the following matters, namely division or delivery of produce. That is one issue which he was before. For this issue, he was before the Bhakcha's officer. Recovery of produce under section 16A. Termination of cultivation by the Bargadar. So his case before the Bhakcha's officer under section 18(1) was clause A. Or recovery of produce, I'm not getting the money, I'm not getting the delivery of produce. His case was not clause B, that you terminate him. So until the Bargadar is given the right to approach, or they should be given a right to get heard by this officer 18, if the termination issue is to come, then the
Who is
BLLR should,
the Bhakchas officer?
the BLLR,
So BLRO now says that you come to me, I will execute the order. Is
no,
it your
no, no,
submission?
no, 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 no. My argument is,
BLRO order, you are saying page
was
20
for,
we understand. Page 21 order, you are saying that that was an application for recovery of the
Their report.
produce,
right.
calculated in terms of money.
That's very good. So BLRO said that you give this amount. If you do not pay this amount, there will be termination.
No, 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 he never said this.
Yes, yes.
He said, if you don't get the money,
Will apply for execution.
execution. That is the usual procedure, Lordship knows.
Execution means execution of the
Of
money.
this order.
Execution of the money degree.
Is this order under section 20 subsection 2 contemplated?
So according to you, while executing this order, neither the BLRO nor the SDO can pass an order for termination of the Borgala.
The executing authority cannot go beyond this order. But executing authority traveled beyond this, saying, you BLRO terminate his Bargadash.
What is the procedure for termination of the Borgala?
That is, my lord, again, it has to be decided. Lord, I have shown your lordship section 18.
So see, he has again has to file the
Because termination was never the issue before section 18 on proceeding. The issue in the section 18 on proceeding was regarding.
Tell us what he is required to do.
Now, my lord, as the learned tribunal has directed, that again you have to approach the SDO, that is the executing authority of section 18(1) order.
That
So
is for execution means for collection of the money.
because that was the only case, my lord, which was asked.
Where is the provision for termination?
that
Tell us.
we have to know.
That is section 18 subsection 1 clause B. Then he should.
Termination is at section 17.
17. And kindly see the C part.
No, section 17, my lord, it says that no
Absurd, my lord.
person shall be entitled to terminate cultivation of his land by the Bargadar, except in execution of an order. Which order, my lord? The order, execution of the order, which is contemplated under section 18, subsection 1, clause B. Because these are the.
Mr. Khalid, just a minute. The order has failed to tender deposit on the restriction of the sale of the produce as required by section 2. And for the case maybe of section 60. Why? Because the effort time made in the town specific in this plot shall be given a that the technology person and the calculation. To model in such time, in such instrument as the officer making the order may have with regard to the always happened this will go. So to see attract হচ্ছে বুঝতে পারছেন তো এই তার মানে গোলক দাদাই ঘুরে গেছে কিন্তু সি তাহলে অ্যাট্রাক্ট হচ্ছে
So you are me now the tribunal says that you go to the SDO.
For execution of the order passed in your favor.
That is for ensuring payment in terms of that order, monetary portion,
Lordship.
not for termination.
Because
Kindly, so who has the jurisdiction to terminate? Tell us, Mr. Gali.
section 18 authority,
Section 18
Who?
authority, who is it?
that is the BLLRO.
Termination. Now kindly come to section 17.
17
Kindly come to
once
section
Lordship.
17. No person shall be entitled to terminate cultivation except in execution of an order made by such officer as the state government may appoint.
Lordship.
First, now come to clause C. On the following grounds, the Borgadar has failed to tender deposit to the full extent of the share as
Yes.
required, as the case may be of section C.
Lordship.
So he will terminate now with the compliance with the proviso.
May respectfully,
Compliance with
may
the
respectfully answer to the Honorable Court's query now, Lordship.
yes.
When he went for a proceeding under section 81 before the BLLRO, his case was, I am not
We
getting.
have understood that.
So now if he wants a termination,
Who will decide? BLRO?
yes, section 18, followed by manual chapter 6.
But who is that officer?
That is a BLLRO section 8.
Very good. We will record your contention that BLRO will now take a decision as regards termination in consonance with section 17 upon hearing the other parties.
Lordship,
Very good.
may I,
No, don't hand over. You
chapter 6, Lordship, kind of manual?
you make us. You are making.
Yes, yes, that is.
So we will record that.
Termination, my lord, proceeding has to be decided.
Whatever happens to the fate of the order for realization of the defaulted amount is a matter to be decided in that proceeding where the tribunal has directed you go to the SDO.
Executing authority.
Now, consequential order towards termination is provided under section 17, which says that if the bhakchas in spite of determination is not paid, then the BLRO would be having the jurisdiction to terminate.
17(1)(c).
That has to be approached, my lord, under
Right?
section 8.
We will ask him to approach.
Lordship, that is what I'm telling, Lordship. The tribunal is also telling. The executing authority cannot say you terminate.
You are saying for the first time he has to go for getting a degree for money. Then
Your
again
Lordship,
he has
My lord,
that
these are the
that
three
is not
issues.
required, my lord. Why, my lord, I'm telling
These
you.
are the issues which are contemplated in the act itself.
Your Lordship,
Because
kindly see
SDO,
the
my lord,
application.
Mr. Gali, you place before us a written instruction that BLRO is the authority in terms of section 17
1C.
to 17(1)(c) to decide the issue of termination. Let that come up before us.
my lord, status report was there. If you will kindly take that
No,
into
that is
account.
regarding to execution. We are not going on that. We will not interfere with the order, but we will pass a direction that this way a person cannot be heckled by going from door to door. It cannot be done. Your BLRO is an officer. He should have called and said that, sir, this is the position. You make an application before me. I will hear them and I will turn.
Your Lordship, my lord, possibly that
My lord,
will not, my lord, that is
executing
not
court.
required. Because, my lord, my learned friend is saying that there is no statement as such so that the execution can be done. Your Lordship, kindly sees my first application. Your Lordship, kindly sees
How
my
can
first
the
application.
executing court go beyond the order of execution?
Your Lordship, kindly sees the application, initial application under Order 18, Rule 1. Your Lordship, kindly sees once, page 16. My learned friend is saying that only for the payment or the process, whether I have made further Lord prayer. Your Lordship, kindly sees page 16. Your Lordship, once, page paragraph 4, page 16.
No, there are no cancellation order was passed. No termination order was passed.
Yes, Your Lordship, kindly sees.
My lord, may
my
I
learned friend
respectfully
is
produce
saying
my lord, chapter
that
6 on manual is very
in absence of the prayer for termination of the Borgadaship, there will be no.
Your purpose is to terminate their.
Yes.
So Mr. Galib is not disputing that. He
So
says
he is saying that without the statement made by the petitioner in his application.
Good, bad, indifferent, BLRO passed an order.
Yes.
So that was his contention is that is pertaining to a monetary amount which has
But
been-
my statement was there.
Very good.
My statement was there. So that জমিতে
prayer
আমি
was
যাতে
there.
ভাগ
Prayer
চাই
was-
Your
Yes,
prayer was
prayer was
that
there.
we have to consider the order.
And thereafter, your lordship kindly sees the page 24. প্রতিপক্ষের নাম নিম্ন তফসিল সেমতে পার্থ না উপরিউক্ত প্রতিপক্ষের নাম নিম্ন তফসিল দাগে যাতে বর্গাদার হিসাবে রেকর্ডভুক্ত করা আছে তাহা কাটিয়া দেওয়ার জন্য
Come with this.
My lord, may I respectfully, I shall certainly come, my lord. May I just respectfully, my lord, produce one, my lord, I'm provision I'm showing, lordship.
সেইটাকে কি সেখানে কি ওইটাকে রিওপেন
application, we will not touch the order of the tribunal. We will say now, recording his contention, that BLRO is the person competent to decide the issue of termination independently.
Lordship.
So we will say, we will direct you that
And
you
on the
fi-
basis of my Milord prayer,
Please
that
listen
your
to
Lordship.
us.
I'm sorry, I'm sorry.
So we will direct you to file an application for termination in terms of the procedure and 18.1, and that termination issue will be decided by BLRO in consonance with section 17 upon giving notice to them and taking a
Your
decision.
Lordship kindly
So
fix
far
a,
as your
fix a time, because
that way.
my client has
now,
already,
so far as the question of execution of a monetary issue,
Lordship.
that you will be free to execute.
I never, Milord, prayed for money. I never in any proceeding, even in the execution or in the initial
Very good.
application.
If you don't want, you don't want.
Yes.
Yes, Mr.
At the cost of castigation, may I just refer to one provision?
Yes.
Lordship Miller was pleased to ask me that the grounds of termination of Bargadar as contemplated under section 17, who is to decide? Miller manual is very much clear in this aspect. Rule 86, it says that the officer or authority appointed under section 18(1) of the West Bengal Land Reforms Act 1955 shall dispose of an application A made for termination of cultivation by Bargadar on any of the grounds mentioned in section 17(1) of the Act.
So, that
So
is-
if you want termination of the Bargadar on any of the grounds contemplated under section 17, section 18 is section 18(1) authority is the authority to decide.
That is the Bhakcha.
That is the BLLR Bhakcha.
Yes,
This is
that has
clear
been-
from this.
That is what we
that
are
has
saying.
been done by the BLRO.
Exactly.
Termination hearing, he has to be, the Bargadar has to be given an opportunity. There is a separate proceeding.
Yes, we are accepting your.
That is what your Lordship is doing now, Lordship.
Yes, we are accepting your.
No, Lordship was pleased to ask me that who is the authority of 17(1), you tell me.
Yes, you are
17
saying-
authority is also 18(1) authority.
You are saying in consonance with the procedure that this person X is entitled to, has the jurisdiction to consider. As you have rightly said, section 18 authority will consider.
Yes.
Whatever tribunal has decided, it has decided.
No.
Now we will say he will make an application.
On the issue of termination, you go before 18 authority.
That issue was already there.
Already there. Already
in
there.
an alternative way.
Now, if we have to
Come to
file a
paragraph
fresh,
page number 16
then it will
last-
not take same time. Lordship.
Sir, allow us.
Oh, Lord, I'm sorry.
Page number 16, last portion, last line. উল্লিখিত জমির ভাগ ফসল যাহাতে আমরা পাই তাহার নির্দেশদানে
Yes.
অথবা উল্লিখিত জমি যাহাতে আমাদের নিজ দখলে চাষাবাদ করতে পারে তার নির্দেশদানের আদেশ।
So on the basis of this application, section 18(1) proceeding was drawn up. Final order was what, my lord? Not alternative remedy. I am giving a monetary calculation of your value, of your produce, you take it. So now he should go for termination.
There is no provision. Lord,
Sit down, Pramada, sit down.
পরবর্তীকালে একটা অর্ডার করি চ্যালেঞ্জ বিএলআরও আবার অর্ডার করি এসডিও ওইটার কানেকশনে অর্ডার যে তুমি কাজ which is your jurisdiction to issue direction for that. Mr. Galib, this can be done because filing of a fresh application, because as his prayer pertaining to clause B was not considered, that cancellation of termination, we can ask that authority to consider that issue and pass the final order.
Lordship is referring to
Because if a
page 16,
One.
alternative prayer.
Yeah.
Lordship knows, my lord, we are making a residuary prayer in all the, my lord.
your Lordship kindly, your Lordship kindly allow me.
Since, no, Lordship can always, but since this application has already attained finality on passing of an order under section 18(1), which was sent for execution, so, my lord, this application, how can the clock be set back, Lordship?
Your
My
lordship.
lord,
kindly have a
termination, my lord, he
provision
can
first.
get
Your
termination.
lordship kindly have a provision first. My lord, your lordship has pointed out this provision. Your lordship, I am inviting your lordship to that provision, or at least. Section 17, clause C. That is very much clear. What execution? What is the only monetary? There is no specific provision.
God, even
Monetary.
But
Your lordship,
Mr. Galib
you
is,
see the manual.
Mr. Galib is saying, what Mr. Galib is saying, you have two prayer. One for execution, one for payment of money
lordship.
or termination.
Yes.
Second portion, you're not allowed.
And in default of payment, this execution clause is there.
It was not allowed. And that order became attend finally.
Your lordship, that is allowed. That is why this last portion of the, your lordship, kindly have a look to the page 21. Your lordship, kindly have a look. There cannot be two execution of one order.
Why
Your
not?
lordship, kindly see the page 21 part once again. The last portion, the Borgada is directed to pay the amount as determined herein above to the petitioner by the scheduled dates, failing which the applicant will be at liberty to apply for execution of this order before the appropriate authority. Your lordship, kindly come to the provision of 70C.
Failing which there is no clause that the Borgada Chief stands.
Yes, Milo, kindly see the clause has been
Should be given.
incorporated.
They should be
Your
given a
lordship, clause has
chance.
been incorporated by the
Hearing, everything has
Your
to be
lordship,
given.
kindly see 17C. 17C said that the Borgada has failed to tender deposit
Yes.
to the full extent of the share of the produce as recorded by the subsection 2 or section 4 as the case be there is the clause is there.
In
Execution itself can be
very
the
much.
termination of the Borgada ship.
Now kindly come. After this order, SDO passed the order
Yes,
for execution,
lordship,
directing that
to terminate.
Now,
Lordship,
SDO has no jurisdiction to terminate.
lordship,
Termination has to be.
that is why
under-
it's directed to.
Wait.
Yes.
So, now when you went for execution, the SDO passed this order.
Thereafter, SDO directed to execute the order to BLRO.
Will not above all.
Direction was SDO has not passed. SDO passed the order that since you have not paid the amount, the termination will affect. Termination will affect.
Oh, ejectment of
Your lordship kindly sees. This is execution. This is order passed by the BLRO. BLRO sent it to the SDO
Very
for
good.
determining
If
the
you want
issue.
a finding, then we will ask him to file an affidavit. We will consider. We were thinking of cut short the litigation so that
In that, your lordship, I will not.
Give you,
No. I will not.
when you are
I will not in the way, my lord.
No, you are not on the way. You are also arguing.
No. Only this thing, my lord. My
No,
client is.
No. We are not
fighting-
asking you to surrender your any right.
No.
If you now today take this point that there is no requirement of any further order, you directly issue order of termination. Since in execution, SDO has said so, and that has to be
No,
carried
your
out.
implemented.
Your lordship kindly pass your lordship order as your lordship fallen from.
So
your lordship.
Bargada will not
Now
get any
the
opportunity of
thing is-
hearing.
Thing is, my lord, my client is, my lord, fighting since last
What is
several years. Your lordship kindly cut short the matter as your lordship, my lord, feeling so, and my lord directed the BLRO to decide the issue, my lord, within specific period. Within specific period, my lord.
application করবে এবং সেটা কনসিডার করবে on the basis of this order. On the basis of the order taken, 24 or any subsequent.
He should go for fresh application for drawing up a proceeding of termination. The other side shall be given a chance also to defend his case. You know, it is a very because 20 subsection 3 said no order for ejectment of Barada shall be executed except during the month of Bengali year. This is so many
20?
tramels are there.
There is no specific.
Section 20, that is the execution section.
Yes.
Kindly sees below subsection 2 is any order made under this chapter, including an order passed on appeal, shall be executed by the officer authorities executing. Subsection 3 says, it was added later in the year 1960, no order for ejectment of a Bargadar shall be executed except during the month of Bengali year specified below so and so. So that gentleman will not be given the opportunity of hearing the termination proceeding. So much protection has been given to him in the act.
No, that is there. That is given. Your lordship kindly sees
How
the
much
SDO order.
protections he requests?
No,
You
Lord.
are arguing for
is there.
the Borgada or you are
Definitely
arguing
not.
for-
No, such a, we are all victim of this, my lord. We are all victim of this.
Services file.
I'm appearing on behalf of the appellant petitioner. I'm challenging the impugned order passed by the learned court below on 12th September 2024. It was not properly agitated. Matter is relating to appointment on the ground compensation appointment. This is the, but it was decided on. It was decided only on the ground that after a long delay, you moved this writ application before the honorable court. But as per scheme, I made the application within 1 year with proper format, and it is pending before the authority. And it appears from the opposition, it has been stated that it is not possible to decide this matter because the application is not located. Wait a bit. That is missing. It has not communicated. It is pending. And it is not the latches on the part of the petitioners, appellant petitioner. Ultimately,
Belated submission.
no,
Firstly, belated submission of the prayer.
no, I made an application proper time as per scheme introduced by the,
Within the specified period.
yes,
Thereafter, what happened?
it is pending before the authority.
Ah.
It appears from the opposition's paragraph 20. It has been categorically stated it is
No,
not possible.
What the learned single judge has said.
Single judge,
Standard
after a
single
long
judge
delay,
has-
you move this writ application before this honorable court. It has elaborately discussed. As per scheme, I meant to get the benefits. I have cited several judgments of the Supreme Court.
Adjust the microphone. Come to paragraph number 27
Paragraph number 27.
of the impugned order.
Impugned order.
Internal page number 9.
9.
Have you got it?
27.
Yes,
After
sit down.
realizing
Please place.
the honorable, in the case on hand, the writ petition after submitting application in the year 2003 did not pursue the matter. I made several representations before the authority concerned. Pursue the matter diligently, accepting, submitting
Just a minute,
representation in the year
Paragraph
2006 and 2015.
Internal page number 9. What is the reason? Yes, sir.
They have not communicated. After filing the writ application,
Place the order first, thereafter we'll
yes,
accept.
pursue in the matter diligently accepting, submitting representations in the year 2006 and 2015. Before filing the writ petition, sometimes in the month of July 2016, the writ petition approached the court almost after 13 years of the death of his father. This court is therefore inclined to accept the contentions of Mr. Sinha that the family of the deceased was able to sustain themselves from other sources. There's no other earning source.
So, Mr. Sinha, you
So-
is entitled to the ex gratia payment under your new scheme.
New scheme came exhaustion payment. New scheme, but he has approached exhaustion payment is there. That is not his prayer.
Yes.
That
No,
is
no,
not
we are asking you. We are asking you, she is entitled.
My lord, he has died.
No, he is entitled to ex gratia payment or not in terms of your new scheme. Tell us.
New scheme exhaustion is entitled, but he has approached the court.
We will consider that. You first tell us what is the amount payable to him for the purpose in terms of your new scheme as ex gratia payment.
Amount, my lord, to calculate, you know, because it depends
Calculate
about
and say
penury
this
is to exhaustion scheme, penury must be there. For that reason, all retirement benefits are to be taken into considerations and the pension he is getting. and he got the retirement benefits pension.
No,
But
I think under the new scheme, he is entitled to an ex gratia payment.
ex gratia scheme came in 2004, my lord.
Right.
And
2005.
4th August 2005. Under that if there also penalties to be considered, whether penalty is there. If there is a scheme, if there is a penalty,
Attitude of the respondents, your lordship kindly.
Yeah, just.
It is misplaced from the custody of the respondents.
13 years.
Or on the date the application was submitted. কিছু কোড বলেছে ডেট, কিছু কোড বলেছে application। এটা হচ্ছে relative controversy আছে না, এবার appointment on compulsory basis না, appointment banking না টাইমে অ্যাপ্লাই করতে হবে না, স্কিম আনবে এখানে দুটো কম্প্রেশনের অ্যাপয়েন্টমেন্টটা তুমি পাবে না, তবে we can consider for inflation পেনশন কার্ডে ইউজ করে তুমি একটা অ্যামাউন্ট consider করছি, এটা কনসিডার হবে সমস্ত ক্যানাডা আপনার কাছে স্কিম যখন এসে গেছে ওটার বেসিসে রিপোর্ট চাইবে, সেটাকে দেওয়া যাবে ও তো কনফিউশন। হ্যাঁ সেটা তো মামলা পাওয়া আছে, মানে ধরে নিয়েছে কোনো টাকা দরকার ছিল এবং কোনো টাকা interfere well inclined to accept this offer but not was able to sustain themselves from other sources. এটা থেকে একটা rare judgments আছে যে dictatorship responded একটা তাহলে বিভিন্ন জায়গা আছে পার্শ্ব আপনার মানে এরকম ছিলাম দেখা যাচ্ছে এরকম একটা আমাদের কাছে ঠিকঠাক কমিটি পাঠিয়ে দিয়েছি চলে না করতে পারি ছেলেটা কপি দিয়ে সেটার বেসিসে মাপা তৈরি না অ্যাপয়েন্টমেন্ট হয়ে গেল স্যার, সেটাই তো বলছি ওইটা নিয়ে
pending for so many years.
Well, 2003 has applied. 2004, there is a record in the bank that is forwarded to the another authority. From there, the competent authority will go. Thereafter, nothing is there. We could not trace out what is the possibility. We have answered it. It was rejected definitely. That is why it's not. But that later,
that is your case work.
my lord. Yes, what I'm saying. What I'm saying, my lord.
Let us understand in our own way.
Now, what I'm saying.
After all, it is a question of bread and butter of a person who has died died in harness. Application was filed admittedly in 2003. Please explain what the bank authority has done.
2004, it appears to the bank's record, it was considered and it will refer to another authority.
Yes.
Ultimately go to the competent authority.
Yes.
From thereafter, whether bank has answered or not, it is not there.
So who will answer?
No, that is not traceable, I'm saying. And thereafter, he was sitting over the matter for 13 years. He could knock the door of the court.
If I say alternatively that you
that is Supreme Court said.
You are not so serious for consideration of an appropriate representation. If I argue in that manner,
no, I was serious, considered.
How can you shift your burden to a person who has lost his father or mother?
That is considered by the Supreme Court in the last judgment, my lord. Kindly look into the
Let us see your
theory judgment.
records. Let us see your records.
But we have seen them. We have searched whether answer was letter was sent. But bank preservation of records, there is some rule. It is more than 13 years.
You
Now, my
disclose
lord,
your-
that such situations are considered by the Supreme Court from paragraph 23, 24, 23 onwards. Kindly read by 2-3 paragraphs. Such to be considered.
Which one?
From 23 onwards, Devrata Darwai is 24. But my lord can start from 23. These are all considered.
No, we are not disputing such proposition.
So
We
that,
are what my brother has asked you. Have you explained that what you have done? You are a statutory.
no, we have said in the affidavit it was not traceable.
Affidavit, where is that affidavit?
He has not enclosed.
Affidavit enclosed করনি।
Sorry, sir. Liberty is given to annexed.
You should have enclosed your writ
Vital
petition, opposition, and reply to this.
He has not enclosed. Only memo and order. Detailed affidavit was
Mr.
filed.
Saha, learned advocate,
Supplementary
appearing for the petitioner, they're coming back after 10.
Well, this appeal arises out
Yeah,
of
for
an
the state respondents.
order passed by the tribunal where the challenge was the order of resumption.
Before learned senior counsel proceeds further in this matter, the main challenge thrown before the learned tribunal was it was upon the virus of explanation 2 to section 6 subsection 3 of the West Bengal State Acquisition Act. So, my lord,
That was one of the challenges.
since that challenge
The
still there,
virus was there.
my lord, I was
We
just
have
bringing
fixed that. We have fixed that matter in
correct.
January.
So
Say
in
section-
fact, on the last occasion, your lordship was pleased to point out that your lordship is hearing another matter.
Yes, we are hearing with Justice Chatterjee,
My lord.
not with my lord.
Very well.
That,
So
that matter appeared, I think, day before yesterday. You were there.
and I was not, my lord, I was
14 January or something like that. We have given.
I think
Minus-
Mr. Shoptanshu Basu is
Yes,
appearing
yes.
for the my lord, I think my lord learned Government Peter is appearing in that matter. I think.
We have, Mr. Bose, we have fixed it on that.
very well. So may I just one suggestion, if I subject to what your lordship feels, may this matter appear along with that, because if the issue
That is what we are trying to ascertain.
Yes.
ওটা মনে আছে কি কার্তিক তোমার? হ্যাঁ, হ্যাঁ, হ্যাঁ। হ্যাঁ, হ্যাঁ।
You sure?
2 p.m.
আমাকে বারবার বলছে কি আমরা জানি
Hard Mr. Bose and advocate. Who is in 6?
I'm for the statement.
কার্তিক কার্তিক চলে এলো কি কার্তিক এই রাজকুমারের নাকি শরীরটা খুব খারাপ হয়েছে ওখানে আমি তো ডাক্তারের জন্য আমরা
The mere correction of record of rights, my lord, that the application pending before the BA and LRO, my lord, he will, my lord, dispose of this, my lord, considering the merit.
You are not diligent regarding causing of service upon the respondent.
My lord,
Then why have
respondent only the BLR. There is no private respondent. The state is appearing when on behalf of this BLRO. My lord, kindly see if order earlier order
be affected?
my lord, earlier order, my lord, kindly page 51. The earlier order, my lord, kindly the earlier order.
You have come against which order?
Coming, my lord, this is this tribunal, my lord, did not
When was the last order passed?
last order is
Oh.
9/9/2020.
further. Is the BLR only this, my lord? His pending application pending before him. The petitioner, my lord, is a
Where is the order of 3rd November?
November order has been annexed.
and number 2002.
Yes.
No, not at it.
How
It is
can,
earlier order. Earlier order is same order.
so it has been fixed as motion in August 2025 because you have not complied with the earlier order of 3rd November.
Only this, my lord, service not affected.
I don't know. Where is the order of 3rd November? Tell us. This 3rd November order, where is it, Mr. Manna?
And only this 3rd November with not, it is not.
So you bring in.
Why are not proposing service?
Was in service, my lord.
No, private
Service has been made,
it
but
was-
the tax report has not been.
যাদের নাম আছে তাদের তো শুনতে হবে।
So I pray.
No private respondent.
না।
My lord,
No private respondent is
no
there.
private respondent.
Then
only the PLR.
whose name is recorded now? Whose name is recorded now in respect
My
of
lord,
the land?
the land has been vested under the Estate Acquisition Act, my lord. The original owner, my lord, preferred an appeal before the special judge, district judge, my lord. District judge, my lord, and set aside the vesting order. Vesting order. Then several order was passed by the Honorable High Court also. 3 orders here annexed, but never cared for. Then present petitioner purchased the land and
Purchase from whom?
purchased from this original owner. Original owner,
From whom vested took place?
my lord. Vesting order was set aside by the district judge on the appeal. Then several High Court order passed, my lord. No correction has been made. And also petitioner, my lord, made
Correction has been made. It is still under Khotian 1.
Khotian 1. Khotian 1. My lord, kindly come to page. The petitioner earlier moved the tribunal, tribunal passed the order, page 51. Or you can see this. Page 51. This is the order.
Just a minute, sir.
কোর্ট তাকে পাঠিয়ে দিলে চলে যায়।
প্রিপোনিং দ্য ডেট তো
দরকার কি বেলারও কি সেটা কিছু করবে না, প্রিপোনিং ডেট
তো আপনার তো ওখানে পেন্ডিং।
স্পেশাল হবে এখানে।
This was passed in whose matter?
Petitioner may not move this tribunal passed this
Why you are showing this order?
order, earlier order.
This is in respect of some other person.
No, my petitioner before your lordship.
Their petitioner Subhash Chandra Jan.
Subhash Chandra is one of the petitioners.
Where is he? না না, এখানে পিটিশনার তো সুশান্ত।
সুশান্ত আছে, সুভাষ আছে।
Then what happened thereafter?
Nothing has been done.
So you were sleeping thereafter?
Sleeping mane
Sleeping mane? What you were doing after that? If this order was not complied with, what did you do?
Since then nothing has been done, then petitioner.
Then how can you come with a fresh original application?
Application.
You bring the 3rd November order.
Page 53. Yeah,
Please bring the 3rd November order. We want to see what the tribunal directed on that date.
Only this
3rd November 2020.
That is it is not with me, my lord. It is only this order, service not completed.
Show us that order.
You don't have any panel in the LRTT? You don't have any panel in the LRTT?
No.
State government panel is not there.
No, Milord. There are government representatives. There are
Who
representatives.
appears usually?
I don't know, Milord. There are so many persons.
Who appears?
PLRO, my lord, appointed.
Here, Milord, the one
PLRO
Mr.
appointed
Shobha
and the
Ganguly is
government-
appearing, Milord. As he appears from the
appointed and the
record.
government dependent,
Do you
they
have
are
the order of 3rd November, Mr.
No, I have no.
What was the earlier order?
I don't know, Milord. What is the earlier order? 3rd November order কি যেটা comply করেননি?
We told you on the last day also.
I shall
We gave you liberty to file a supplementary evidence.
Lordship.
Still, you are not bothered. You are not bothered about the orders passed by this court.
But it's similar service not completed. Only this.
You took you took a leave from us that I am coming with that order and the documents. I will file a supplementary. We would have dismissed on that date. You did not allow us to do so. You said, "Come, please wait. I will come with the supplementary." Now you come with the. Now they see this order, pass this order. But what is this, Mr. Varma? Some amount of decency has to be maintained, na?
Lordship, it is a duty of the tribunal.
What was your duty after we passed the order of 21st June? Huh? You are pointing out other duties. You failed to complete your duties.
Come back with that order.
2 weeks adjourned. Yes, please. Yes, next.
This is my writ petition. Millard, the predecessor in interest of the petitioner Millard, he became the owner of a particular land in question, Millard. And Millard, after his demise, Millard, during the pain, Millard, he was recorded as a riot. If your lordship, Millard, kindly take pain, Millard, to turn Millard the page, Millard 58.
You are not going to the merit. What is the order you want? 24th March, it has been fixed.
Millard, yes. Learned, my lords have got it. Yes, Millard. The learned government representative present, learned counsel for such and such, learned government said that submit that Mauja such and such has been fully published, so there is no provision for entertaining PR under such and such. Regarding 44.28 has become time bar. That apart, section 45 is not coming under section such and such. Millard, I beseech your lordship, Millard, to turn.
Point of maintainability is yet to be decided by the learned tribunal.
Millard, kindly sees, Millard, what is Millard 51A?
Mr. Bose has no merit in the matter, so he is trying to show us other documents.
No, Millard.
That you should understand.
No, Millard. Millard, it's a judicial mind, Millard. I can reopen it at any time.
Here has committed.
But I have that. Your lordship also knows that. Yes.
No, Millard.
Yes, that is a major error.
No doubt. Millard, we are
A major error.
we are not happy about it, Millard. None of us.
Why you have done so?
It's the draft of Millard. There are 2 points, Millard. One, judgment.
He has respect for you. That is why he is saying. He respects you.
Yes, Millard. Yeah.
How can we help you, Mr.
Millard,
Bose? We
Millard.
can ask the tribunal to dispose.
No, Millard. Only Millard.
We will ask the tribunal
Millard,
to
here, Millard,
dispose.
I have not come here, Millard, to question, Millard, the record of rights. The point is, Millard, I have come here to incorporate my name on the basis of the civil court's decree, which Millard set aside, Millard, section 6, as well as Millard, the High Court has directed your Lord Division Bench of your Lordship's Court, directed to change, Millard, the record of rights. This was not done. Millard, we approach. Now, Millard, today the tribunal misdirected itself, Millard, by quoting, Millard, that it is a submission not the recorded. This has no relevance and no connection, Millard. Kindly sees what the tribunal has recorded.
Action has to be taken by them, na?
Millard,
Then we
kindly
can
sees.
scrutinize
Yes.
it.
Millard, only Millard, first of all, Millard, that I have never.
From Mr. Bose regarding to 1997. Is this the finding or the
No, this is, Millard, let the matter appear in the list for hearing on 24th.
just one
No.
line prior to
Yes, my lord.
that. One line
sorry.
prior to that.
It is only submission recorded.
Submission record.
Right, your lordship is right, absolutely right.
It is not
Eh,
the finding.
Yes,
This was the primary relief sought in the application before the learned tribunal. If your lordship kindly sees page 46. I'm sorry to
No, no.
interject, my learned senior. Page 46 is the prayer of before the learned tribunal. The first prayer, my lord, the primary prayer. So on this issue, the tribunal has kept the matter pending. This was the primary prayer.
yes. But Millard, the question is, Millard, that I have said my father's name was recorded in RS torture.
This was the first date of hearing.
This was
প্রথম দিন, এটা প্রথম দিনই এটা হয়েছে?
It was the first day. It was the first day.
So it is on that point itself. You are not going to file any opposition.
That point has to be decided. Maintainability has to be decided first.
No, Millard, then if that is the question of maintainability, Millard, kindly decide this, Millard.
How can we decide? Mr.
No, Millard, because this
We are
submission,
not
Millard.
the court of first instance.
Yes, Millard. But I request your lordship, Millard, to have the charity to consider only two aspects. Millard, when the facts are clear before the honorable tribunal, the recorded submission, Millard, that was made, tribunal ought to have said, Millard, possibly subject to correction, that these submission, Millard, submissions do not bear on this issue.
It is your prayer. He
My
has
prayer,
quoted your
but Millard,
prayer.
my Millard, your lordships can mold my prayer.
Please enlighten us in which portion of the order you are acting.
Millard, I am agreed because, Millard, this matter could have been disposed of only on the point whether the civil court's decree or the high court's affirmation could have been acted upon by because I am not asking the BLLRO or the revenue officer to, Millard, correct. I said, Millard, incorporate my name in terms of the civil court's order, which was affirmed by the high court. Now, Millard, today there is one judgment which might against me of the division bench presided over by Justice.
This point at the time of hearing of the maintainability point hearing.
Asho, affidavit of service.
Millard,
Yes.
no adjournment should be unnecessarily granted if it is. A preponement of the date if possible, if I may make this prayer. There are,
Preponement, you have to make an application.
yes. I have to make an application, the tribunal may kindly consider.
Then we will
আমাদের
dismiss
বয়স
it.
হয়েছে, হ্যাঁ? Millard, we are,
You want us to dismiss it?
no, Millard.
Preponement you will file next date is fixed on March.
March, Millard, all are, they are all evening in of their life, Millard, and Millard deathbed. That is what I'm saying. Otherwise, I would not have disturbed.
What prayer you want from us, tell us. To prepone the date.
Yes, and Millard dispose it of within, Millard, a certain period.
Affidavit of service as file be kept on record. Mr.
আমি তো ফোন করে দিয়ে যাচ্ছি। ঠিক আছে।
ওই এক একটা সেপারেট কেস শুনতে এসে দুটো কেস আছে, একটা একটা 3 নম্বর, একটা 5 নম্বর, দুটো প্রসিডিং টক্কটার কানেকশনে পেয়েছে। এটা আগের ম্যাটার। Yes, what is this one?
Well, this is my if service. I forgot to file the same
I
last
for
occasion.
number 1 and 2, the state of West Bengal.
You were dismissed. You were dismissed from service.
Yes, my lord.
So why you are challenging now? You have not been paid money.
No, my lord. I on the last occasion, my lord questioned
Eh.
that my illegal removal has not been challenged before this appeal court. So why a challenge under? So, but in
You have
paragraph
filed this matter in 2016.
yes, and
Your punishment, what punishment was issued upon you?
2000.
Dismissal.
no punishment by the charge sheet and final order. I was terminated.
You have not challenged the order of punishment.
No.
You preferred the writ petition saying that give me the service benefits due.
No, there are two prayers.
Come to page 13. What are the two prayers? Prayer A.
A
The service
is
benefits due to the petitioner in respect of service rendered.
Prayer A is to disburse the service benefits due to the petitioner in respect of service rendered by the petitioner. And prayer B to allow the petitioner to join his duty as mechanical helper forthwith.
How? You
No,
were
my lord-
you
my
were
lord-
a
my lord-
dismissed employee.
Yes,
When were you dismissed?
dismissed on
17th
October
October
2000.
2000.
Let me allow me to submit, please.
17th October 2000.
Yes,
So why didn't you challenge that order?
my lord, some facts have been averred in the application, but in the not challenged in specific manner.
Listen, if you don't
Kindly
want to
see.
answer our query, don't answer.
Yes,
We are making, you also know what we are saying.
yes,
You
my
are
lord.
showing us, I have another. We are
Yes, ma'am.
asking you a simple question. Did you challenge the order of punishment? You have
No,
not
but
challenged.
technical not challenged.
So, sir, so
Not-
when you have not challenged the same, the court said that all right, whatever dues are there, I find gratuity this much, PF this much, you pay this amount to the person. So what is the wrong in the order?
Well, wrong in it that paragraph 7 it was averred. That was 17 October 2000 and the charge sheet was by annexure P5, but somehow this omitted to challenge the removal of the order of termination.
Then how can we help you? Tell us.
My lord, I am. My lord, this is a constitutional court. My client is citizen of India, but somehow the court is decide that this right is being snatched. So to protect this snatch by the state authority, I filed a to fill up a lacuna affidavit supplementary. This in the paper from 38 onwards with the leave of the court. Justice Talukdar granted me leave to file the affidavit supplementary at page 38.
We are asking you a simple question. If the order of 17th October 2000 has not been challenged, can we say that that order is bad in 2024?
My lord, the order was otherwise bad to some extent. That is, I did not pray for any gratuity. Payment gratuity was paid in 22, but order was passed in 16. So and language of the order is at page 30, 31. The exercise of releasing the entire payment due to the petitioner upon the petitioner accepting the order of punishment should be completed within 6 weeks from date. So within 6 weeks, it was not paid. I was paid the PF gratuity which usually I was entitled to. PF gratuity we were usually entitled to. And I had area salary also. Well,
Mr. Manna, we have failed to understand how you are aggrieved. That we have failed to understand.
my lord, we are agreed that without giving proper hearing.
Whereas the prayer B of your writ petition, that cannot be entertained at this stage, since you have not challenged the order of punishment. So it has reached finality. So far as dues is concerned, that has been duly taken care of by the learned single bench. So what will do? What you want to? What more you want from us?
I want that my termination was illegally done by the state authority, and I was very much within service. So now I retired from service in 31st March, August 21. So I pray for area salary.
It cannot be done. We have to file a separate writ petition challenging the punishment as awarded against you.
My area salary is there, is not paid.
Exercise of releasing the entire payment due to the petitioner upon the petitioner accepting the order of punishment. I mean, he has not accepted the order of punishment as
NSR was there for the termination, illegal termination, but appellant is present in court as I talked earlier.
you. Where is the order of 8th April 2016 passed in the writ petition earlier? Ajay, Mr. Banerjee, can you come to the page 31?
31.
Court said that exercise of releasing the entire payment to the petitioner upon the petitioner accepting the order of punishment. So the petitioner did not accept the order of punishment.
The next paragraph, my lord, only says the liberty given is that, my lord, writ petition is disposed of by leaving the petitioner free to question the quantum of payment tendered by the employer, if there is any reasonable ground therefore. So only question left open was if the payment is he's agreed by the payment, he can challenge the quantum of payment. So, my lord, validity of the termination was not kept open for him to challenge. Now
But the sentence says,
My lord.
subject to acceptance of the punishment order, release the dues. So he is not accepting.
He might not accept, my lord, but when the petitioner, my lord, challenges,
সেটাই বলছি। Yes, what you are wanting, we don't understand.
My lord,
Petition, you have make out a case for setting aside the order of punishment.
not specifically, but
Yeah.
by showing annexure, there is there charge sheet, etc.
So show me the relevant ground.
My lord, kindly come for a moment.
You have taken for impugning the punishment order.
My lord, come to page
2000
paragraph page 5, paragraph 5 of the writ
No,
petition.
Mr. Banerjee,
My
let us know from the order of punishment, it was an unauthorized absence for about 21 days. So you have punishment you are imposing is diced on. Then how you are calculating to disburse his pensionary benefits?
the punishment order is that
Means,
page.
diced on means, does it mean that there will be break-in service? If there is break-in service, then he suffers substantively. Diced on, if you are saying
For
that
that.
no, he may have been engaged sometime since say 1990, we do not know. So from when did you join?
Oh,
What is
my lord, 85, my lord.
what is the effect of we are wanting, Mr.
My lord,
Banerjee?
I understand. What is the effect of, my lord, the
Diced on
treating of diasnon?
for
Order.
21 days, for unauthorized absence for 21 days. Now, if it is, if the employer says he was appointed in
3 for 85, joining date.
Huh?
3rd April 85.
3rd April 85.
Page
So there
23
is
is
an
the punishment.
interpretation of diced on. We don't know what your authorities.
I am not representing the authority, I am representing the state. CSTC is an autonomous body. Mr. Amol Sen normally appears for CSTC. I represent the state. But so far as this challenge is concerned, so far as my stand is that, my lord, he has accepted the order, my lord.
I understand that is the challenge you are making. We are trying to ascertain.
My lord.
He has not substantively challenged the punishment.
No, and he did not challenge, give representation against the charge sheet, and the inquiry report also he did not reply. That is recorded at page 23 in the punishment order. Kindly see.
No, this is one side reply. That is the supplement affidavit I relied upon.
What
Supplement come page 38 of paper book.
Order records, order of
I
punishment
filed
records that reference to this, commenting to charges framed against you, and your written reply having not been submitted. Matter inquired into. After inquiry, the inquiry report was endorsed to you. You did not submit any representation in respect of the inquiry officer's report. So, not possibly after not giving
So
reply.
did you join thereafter?
No.
Huh?
The leave was granted from 7/12/97 to 30/12/97. Leave was granted. That is annexure page 19. And thereafter, I went there in January 98 to take me in service. But they delayed the matter and wait for this. They didn't allow me to join there. For the reason that I had the ESI doctor facility up to December 97. But from 98 January, it was off and did not accept the private doctor certificate.
You were working which post?
I'm mechanical helper, but I am the expert mechanical helper. I was sent many times for heavy jobs.
Then from 97, what are you doing?
In 97, I kindly see.
After 97, order was passed in 2000. You filed the writ petition in the year 2016.
That I stated at page 6, page 43, running page 43, paragraph 28. Running page 43, paragraph 28.
কথাটা বোঝে না। Your punishment was of which month?
My lord, I've stated that
Only beating about the bush. You don't answer the query of the court.
I several times visited the office requesting for joining, got no salary, and I suffered acute financial hardship in
So
starving
you
condition.
are in any other job. You are an employee. You are remained sleeping in your place for 8 years. Huh?
And
You are taken away your bread and butter, and you are sitting at your home.
No, regularly visiting the office.
So
But
who told
wait,
him not to come to court at that time?
my lord, he
My
requested.
lord, and you have not written a single ground of challenge or punishment. In appeal, you want to open the Pandora's box. Give me this, give me that.
My lord, he says that Ashok Kumar Jana contacted.
He has suffered. Even in 2016, you did not properly challenge the order of punishment.
My lord, he believed on the advocate, my lord. That is the to cover the lacuna. I amplified everything on the supplementary affidavit. He made to advocate Mr. Ashok Kumar Jana. He asked for rupees 10,000.
When were you engaged in the matter?
When?
When were you engaged? While filing the writ petition?
No, no engagement.
Huh?
He was sitting in the. He used to.
Mr. When Mr.
I joined just during Corona period. 21. File local nama.
You did not sit with your client and put this question that why did you sleep at your home for this?
I questioned that time. I filed supplementary stating that Ashok Kumar Jana advocate was appointed, requested charge 10,000 rupees. We could not file it. Page 43 of the paper book.
ওর কাছে যখন এসছো একটা রিপ্রেজেন্টেশন লিখে দিয়েছে। When are you retiring? When are you retiring?
Yes, when I'm 31st August 2021.
You have already retired.
Retired.
21.
21.
Then have you got any pensionary benefits?
Yes, I stated in the last paragraph. In month of April 22, I received through NAFT 72453 and 52650 the PF and gratuity, but some area salary is still due.
Area salary still due means?
Still due means some enhancement on salary was during 1995 and it was billed and paid to other staffs in 2005, but that was not paid to me as yet.
Where have you stated in your petition? Writ petition, where have you stated?
My writ petition, not it is covered, but I filed in the supplementary at page 44. I admit it was totally poorly drafted by the learned advocate.
Payments are subsequent payments. After the order of the Honorable Single Bench,
after 6
these
years
payments were made. He says that area salary part was not paid.
Yes, it was, area salary was told in the writ petition.
2 components were paid, but the area salary was not paid. That is his content. Para 35, page 45.
Respondents paid my gratuity and provident fund through such and such, and as well as recorded in the Impunjaya. My main prayer was to join in service. Was not considered. But challenge you know.
Which period salary you are entitled? Which period enhancement you are entitled?
I am entitled. He said, I have stated. Page 44, kindly see. Para 33. Page 44, para 33. That I am entitled to area of 39 months from the year 1996. For example, area bill number 589, etc., which is known to me.
903 and 905.
This is one bill I have knowledge, but I have other dues also.
Oh, that you are thinking, you will not write down. Which period?
No, I do not know. I do.
Then you
paragraph 32, in paragraph 32, you have paid for back wages.
Paragraph 32. Yes, I have illegal.
32.
Yes.
You want your back wages.
33. 33. 32 is
32. I've been illegally
terminated from my service.
I'm entitled to my entire salary till my retirement. It is a back wages.
Back wages.
Without setting aside the punishment.
No. I see this submission. I humbly pray for the immersion of the same. It is submission. But the
Mr.
below.
Sen appeared last time.
Before the read court, he appeared, my lord, but no, in the read court he appeared. Page 30. উনি কি appear করেছে? অমল সিং করেছে appear?
Heard Mr. Manna learned advocate appearing for the appellant and Mr. Banerjee learned advocate appearing.
No, directly to CSTC.
Service as file be kept on record. Yes.
Mr. Banerjee, Mr. Sen is still representing CSTC?
Yes, he appears for the
Where is he?
transport corp. I'll also personally inform him.
Banerjee, please tell Mr.
Yes,
Sen
yes.
that we have asked him to ascertain from his service records that any further dues are payable.
Payable
to
or
him.
not, my lord.
To say that court has asked him for
My
this
lord.
and to
So that
come
he
with
comes
the-
ready with this instruction.
and let him come with a written instruction to that effect,
Yes,
because he will automatically pray for time.
My lord.
You please, as our officer,
My lord, I
please
shall.
inform him
I
so
shall
that
inform.
he can take the information.
Specific instruction on the next
Uh,
day so that it
that
can.
how much is anything at all is due and payable on.
I shall.
Yes. Stop. Stop here. Come next week, Mr. Shamim.
Yes, my lord.
Next Thursday. This is with Justice Chatterjee, na? Yes.
My lord, kindly pass an order only to the effect that Mr. Omnaran Rai was appearing. That now he has gotten a senior gown. Possibly, that he cannot appear without junior. He said that he has resigned from the panel of the bank since he has become a senior gown.
Give a notice to the bank that it will.
Can you pass an order? Otherwise, may not be effective.
How we know that Mr. Rai is no longer there? He
But I
can
have
act
been,
as a-
I have been informed by Mr. Rai, so can you record that?
he can act as a senior in the matter.
Yes, he can,
bank-
provided bank appoint any junior.
Yes, for that he will send necessary instruction. How can I say that you ask the bank?
Only thing I am apprehending, I have been removed from 2017.
Keep your apprehension at bay. Come back on Thursday. Yes, next.
My lord, I am appearing for respondent number 225, my lord.
Item 10.
Mr. Ali, would you come back next Thursday? Because we heard it with Justice Chatterjee, who would be returning on Monday.
As a lot, please.
It will be there in the list next Thursday.
Next Thursday.
Next Thursday.
Lord, may I place those, your lordship wanted that your lordship judgment to be placed. It is a case of GPF to EPF conversion.
Mr. Ali, give her a copy so that.
My lord, I
I've
have a
given a
copy.
copy.
I have copy.
So have you spoken with your clients? You
My
are
lord,
for
my lord,
Allahabad Bank, na?
no, my
No,
lord,
no,
I'm for
sorry, you are,
WBTC, my lord, led by Mr. Mojumdar.
no, you are appearing for
WBTC,
West Bengal
West
State.
Bengal Transport
So
Corporation.
you please ascertain, take a written instruction from them, because in respect of CMDA, we passed an order in the facts and circumstances of this case. However, if you do not say that this is distinguishable, we will hear it.
My lord, in my humble opinion, my lord, I believe that this is distinguishable. However, my lord, I'll take.
All right, very good. Then Mr. Ali, come back on Thursday.
Thursday.
My,
My lord, may I place this gentleman?
No, you keep with you.
All right.
my.
Yes, sir.
When-
My lord, Mr. Parthok is appearing for the appellant in this matter, my lord. My lord, due to some difficulty, he is not able to appear, your lordship. Due to some difficulty, your lordship, he is not able to appear today. Yesterday also he mentioned, your
Next
lordship.
Thursday. They did get the
Grateful.
এদের আসতে ঠিক আছে এটি হচ্ছে যখন মামলার সঞ্চিত
Actually, we are appearing for the CPI.
My lord, I was asking Mr. Well, I would like to know how your lordship would like to, because we are in respect of 1 to 4, Mr. Ganguly is there.
I'm
Uh,
there in 1, 2, 5. And I'm assisting Mr. Mukherjee in 6.
My lord, 7, 8, 9 is mine.
I'm in item number 3.
My lord, I am item number 4.
As you decide, Mr. Mukherjee, Mr. Basu, whoever
No,
wants
Lord,
to
there
address
there
this-
was a difference of opinion between two honorable judges. Madam Mr. Arijit Banerjee granted bail mainly on an interpretation of Article 21 of the Constitution of India. But that was not considered by Honorable Justice Apurva Sinha Roy. In his lordship's view, the accused person and influential person, they should not be granted bail. This is the difference of opinion between the two honorable judges.
And my lord, the difference, another difference is there. My lord, Justice Apurva Sinha Roy gave his judgment in 2 parts, Part A and Part B. Now, Part A, he rejects the application. And in respect of the other 5 private respondents, my lord, he granted bail. So it's a sort of a half, 1.5 reference, sort of, half reference, sort of. Because Justice Banerjee granted bail to all. He granted bail to 5 and rejected 5.
Those 5 are
before your lordship.
Sir, we have brought the judgment of the Honorable Supreme Court with regard to the authority and the jurisdiction of the Honorable Judge to whom the case has been referred to as the third judge. But this is the judgment, paragraph 7.
Mr. Basu, you are for item number
4. Item number 3.
You're in item number 3.
All the application, the same issue is in.
No, no, very good.
Yeah.
You can address us the points. So if you want to show me any portion of the order or anything like that.
No, Lord, I'm telling you, Lordship, Madam Mr. Banerjee has
On the ground of
Article 21. And Madam Mr. Apurva Sinha Roy did not consider, I mean, that was his Lordship's view. The interpretation of Article 21 and the applicability of Article 21 with regard to the case of the petitioner whose prayer for bail has been rejected by Justice Apurva Sinha Roy. His Lordship's view is they are all not influential persons.
My lord, how do your lordship propose to hear us? That's one thing, my lord, you would like to ask, whether we read both the judgments together today and then start it, or whatever your lordship tells us, how do we go? Or we take our petitions and then hear it. But your lordships.
Or your lordship can go through.
You can point out the grounds on which the bail was allowed by Justice Banerjee.
Article 21.
It was rejected.
Then you argue on the basis of that. Show me the judgment.
Or your lordship can go through both the judgments and fix a short date for us to address your lordships.
No, Mr. Basu, I fixed it so that you can.
Very well. Very well.
We are ready.
Very
We are
well.
ready.
Very
I'm
well.
grateful, man. Grateful.
Let someone place the judgment.
The entirety is not required to be.
No, if your lordship, I'll just give a copy of the judgment in this form.
I have.
In the server form.
And Mr. Mukherjee, you are appearing for the respondent numbers
6, 7, 8, 9. In 6, my lord, I'm with Mr. Ganguly.
And Mr. Ganguly is in 1,
I
2,
am in
and
1, 2, and 5.
Then who is for 4?
My lord,
My lord, I'm appearing on item number 4. Apni
3.
3.
1, 2,
Both of the matter, my lord, 3 and 4, I'm an advocate record, but specifically item number 4 is specifically I'm appearing. And Mr. Basu Senior Counsel is item number 3, 4.
Mr. Basu is for Ashok Kumar Shah.
In one of the applications.
One of them.
Start karo tumi.
No, give it a place karo na.
Puroটা my lord to khali relevant part.
Relevant part.
My lord. Uski relevant part ki bات. তো মাছটা চেষ্টা গাড়িতে ফেলে আমারটাতে ওটা আমারটাতে
বেটার হচ্ছে মাইলড এটা পড়ে নিন তুই এটা দেখতে
এটা দেখো একটু my lord, if your lordship will please come to hey তোরা বস না সব বস না এটা তো চলবে let's sit and do it ঠিক আছে তুমি বসবে না আমি
হ্যাঁ তুমি করো না আমি তো বসে যাচ্ছি
my lord, if your lordship would please come to Justice Banerjee's order, the relevant part if your lordship sees The first thing, my lord, I would like to bring to your lordships to paragraph 2. The Code of Criminal Procedure does not define the word bail. Black's Law Dictionary, 4th edition, defines bail as security for the appearance of an accused person on furnishing which is released from custody pending trial or investigation. The object of bail is to procure the release of a person from legal custody by undertaking that she shall appear at the time and place designated and submit herself to the jurisdiction and judgment of the court. Bail jurisprudence, para 3, very important. Bail jurisprudence pertains to the laws, rules, and judicial decision governing the release of an accused person from judicial custody pending trial or investigation. It encompasses an under trial person's right to liberty, the presumption of innocence, and fair trial, while keeping in mind the state's interest in ensuring administration of justice.
Yes.
And preventing potential harm to the society. Bail jurisprudence ensures that an individual is not unnecessarily detained in judicial custody if he does not pose flight risk or danger to the society at large pending trial. It strikes a balance between protecting public safety and ensuring that the rights of the accused persons are respected. Now, my lord, if your lordship, he gave certain judgments, my lord, he has referred to certain judgments.
Yes.
Then comes to paragraph 6.
Yes.
The fundamental principle of our criminal jurisprudence is that a person shall not be deprived of his liberty. On page 6, para 6. The fundamental principle of a criminal jurisprudence is that a person shall not be deprived of his liberty except for having committed a clear breach of law. If there is no real risk of an accused person fleeing from the course of justice or influencing the trial, there is no reason why he should be kept incarcerated or in a correctional home during the period of his trial. The basic rule always was and still is to release such a person on bail, unless, of course, there are clear circumstances suggesting the possibility of the person disappearing or thwarting the course of justice. Various decisions of the Honorable Supreme Court have held that the bail is refused, it is a restriction of personal liberty of the individual guaranteed by Article 21 of the Constitution, and therefore such refusal must be rare. In this connection, one may refer to the decisions. Now, thereafter, if your lordship will please come, the judgments of the Supreme Court. Now, if your lordship please comes to paragraph 9 at page 8.
Yes.
Please start from paragraph 8, my lord. Paragraph 8. In this connection, one may also note that a constitution bench of the Honorable Apex Court in the case of so-and-so, 7 judges bench, has laid down that although speedy trial is a fundamental right of an accused under trial under Article 21, yet court cannot prescribe any specific time limit for the conclusion of a criminal trial. In a recent decision in the report of so-and-so, the Honorable Supreme Court observed that if the state or any prosecuting agency, including the court concerned, do not have the wherewithal to protect the fundamental right of an accused to have a speedy trial, as enshrined in Article 21 of the Constitution, then the state or any other prosecuting agency should not oppose the plea for bail on the ground that the criminal crime committed is serious.
Please lay emphasis on that.
Crime committed is serious.
Yeah.
Article 21 of the Constitution applies irrespective of the nature of the crime. The Honorable Apex Court further observed as follows. We wonder by what period of time the trial would ultimately conclude. My lord, may I say in this case, my lord, cognizance has not been taken as yet. Cognizance has not been taken even though sanction in respect of Dr. Partha Chatterjee has been given by the governor. But in respect of the other public servants, my lord, no sanction as yet has been given. So, my lord, we do not know when the trial will start and when the list of witnesses and the documents, my lord, I'll come to that later on.
Uncertain. Uncertain.
Very uncertain. I'm grateful, my lord. We wonder by what period of time the trial would ultimately conclude. Howsoever serious a crime may be, an accused has a right to speedy trial as enshrined under the Constitution of India. Over a period of time, the trial court and the high court have forgotten a very well settled principle of law that the bail is not to be withheld as a punishment. But we are all more than 2.5 years in custody. 2.5 years in custody. It was further observed that refusal to grant bail is an unjust punishment leading to prisonization of an accused who is presumed to be innocent until proven guilty. Then, in an article captioned an analytical study of bail jurisprudence and the discretionary power of courts relating to bail in India, published in volume 4, issue 2 of the International Journal of Humanities, Social Science and Management, the joint authors of the article have noted that by allowing the accused to be released on bail, bail jurisprudence contributes to the efficient functioning of the legal system. It reduces overcrowding in prisons, minimizes delays in trial proceedings, and enables the accused person to participate effectively in their defense. In the same article, the authors have opined that the following are the factors which a court should take into account in exercising its discretion judicially while hearing a bail application. Nature and gravity of the offense involving violence, economic crimes, or threat to national security. Evidence and prima facie. Flight risk. Criminal liability. Criminal history, victim rights, and public safety. Special circumstances. Then, paragraph 10, as your lordship sees, one thing, may I just to reduce the burden on your lordships by reading the whole thing. May I ask my learned junior friend who has made a small, Mr. Ganguly.
Let me the junior most place it before your lord. Yes.
Youngers have always appreciated.
So this yeoman's task, let me do it. Let my learned seniors not do this. My lord, paragraph 10. Bail should not be denied. Well, paragraph 10, page 9.
Yes.
Bail should not be denied as a form of punishment prior to conviction. One must remember that unless guilt is proven, there remains a presumption of innocence under criminal law. The guilt must be established beyond reasonable doubt. Denial of bail also affects the right of an accused to a fair trial, since he has very limited contact with his lawyers, and that too in a tightly restricted environment. A person on bail has a greater opportunity of preparing or presenting his case than one who is detained in judicial custody. As was observed by Justice Krishna Iyer and quoted in Aero Traders Limited versus Ravindra Kumar Suri, mechanical detention should be reduced if public justice is to be promoted. In several decisions, the Honorable Supreme Court has laid down the considerations for grant or refusal of bail to an accused in the case of a non-bailable offense. They are, the first is, whether there is any prima facie or reasonable ground to believe that the accused has committed the offense. 2, nature of accusation and evidence therefore. 3, gravity of the offense and punishment which the conviction will entail. 4, reasonable possibility of securing presence of the accused at trial and danger of his absconding or fleeing if released on bail. 5, character and behavior of the accused. 6, means, position and standing of the accused in the society. 7, likelihood of the offense being repeated. 8, reasonable apprehension of the witnesses being tampered with. 9, danger, of course, of justice being thwarted by grant of bail. 10, balance between the rights of the accused and the larger interest of the society state. 11, any other factor relevant and peculiar to the accused. Then 12, while a vague allegation that the accused may tamper with evidence or witness may not be a ground to refuse bail, but if the accused is of such character that his mere presence at large would intimidate the witnesses, or if there is material to show that he will use his liberty to subvert justice or tamper with evidence, then bail will be refused. Then the various judgments has been referred.
Mr. Ganguly, you may take me to that portion where this clause 12, this influence of witness, that has been discussed by his lordship. I think it is from para 20, okay, from para 16 onwards, quoting that K. Najib's judgment.
Yes,
That
my lord.
Senthil Balaji's judgment, which was,
These have been extracted.
I think my lord's reasoning was from dealing with the, from paragraph 16 onwards, my lord has 24. Or that is what I'm what I see.
25, if your lordship
If
kind.
you still want to show me any
No.
particular
Those are extracts from judgment.
Yes, sir.
From 25, kindly takes it up 18. Considering the gravity of the offense in such statutes, expeditious disposal of trials for the crimes under these statutes is contemplated. Moreover, page 18. Moreover, such statutes contain provisions laying down higher thresholds for the grant of bail. The expeditious disposal of the trial is also warranted considering the higher threshold set for the grant of bail. Hence, the requirement of expeditious disposal of cases must be read into these statutes. Inordinate delay in the conclusion of the trial and the higher threshold for the grant of bail cannot go together. It is a well-settled principle of our criminal jurisprudence that bail is the rule and jail is the exception. These stringent provisions regarding the grant of bail, such as section 45(1)(3) of the PMLA, cannot become a tool which can be used to incarcerate the accused without trial for an unreasonably long time. This is also being extracted from another judgment. This was in Senthil Balaji.
Yes.
In that, there is under section 45, there was a restriction.
Yes.
Like section 37 of the NDPS Act. In so far as the sections we are concerned with, there is no such higher threshold for grant of bail.
Despite that restriction, the Constitutional Court, Supreme Court and the High Court have a right to grant bail on violation of Article 25.
That was what was decided
That
in.
is what was stated in para 24. What you are submitting, that is in a higher threshold is provided.
Yes, the higher threshold is the
NDPS and
yes,
that section 37 higher.
equivalent to those.
There is no such proposition here in the present.
20, then paragraph 26 of that judgment, Senthil Balaji. There are a series of decisions of this court, starting from the decision in the case of K. Najib, which hold that such stringent provisions for the grant of bail do not take away the power of constitutional courts to grant bail on the grounds of violation of Part 3 of the Constitution of India. We have already referred to paragraph 17 of the said decision, which lays down that the rigors of such provisions will melt down where there is no likelihood of trial being completed in a reasonable time and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. One of the reasons is that if, because of such provisions, incarceration of an under trial accused is continued for an unreasonably long time, the provisions may be exposed to the vice of being violative of Article 21 of the Constitution of India. Some days, the courts, especially the constitutional courts, will have to take a call on a peculiar situation that arises in our justice delivery system. There are cases where clean acquittal is granted by the criminal courts to the accused after very long incarceration as an under trial. When we say clean acquittal, we are excluding the cases where the witnesses have turned hostile or there is a bona fide defective investigation. In such cases of clean acquittal, crucial years in the life of the accused are lost. In a given case, it may amount to violation of rights of the accused under Article 21 of the Constitution, which may give rise to a claim for compensation. As stated, then 15 months he was there. So
They emphasis on that. Here, 15 months, the person concerned was in incarceration.
the appellant has been incarcerated for 15 months or more for the offense punishable under the PMLA. In the facts of the case, the trial of the scheduled offences and consequently
Where you are reading, Mr.?
Paragraph 29 at page 19.
No, that is not the Senthil Kumar judgment.
Well, it's not matching.
Page 19, paragraph
That is
17.
mentioned in paragraph 16, I suppose.
Right.
No, no, Senthil Balaji, that is the judgment you are showing.
Yes, Malad, paragraph 29, your lordship will get in page 19, or is it not matching?
No, no. Page, yes. Page 19.
Malad, this 28, 29, these are all extracts from Senthil Balaji.
Senthil Balaji, all right.
So paragraph 29, as stated earlier, the appellant had been incarcerated for 15 months or more for the offense punishable under the PMLA. In the facts of the case, the trial of the scheduled offenses and consequently the PMLA offense is not likely to be completed in 3 to 4 years or even more. If the appellant's detention is continued, it will amount to an infringement of his fundamental right under Article 21 of the Constitution of India of speedy trial. Now, in this case, my Lord Justice Sinha Roy had held that since sanction is not being given by the government, that indicates that these persons must be influential, and that is why the state is not giving this sanction, and therefore the trial cannot proceed or cannot be initiated due to these circumstances, and therefore the prosecution is not liable. But perhaps my lord was perhaps failed to look into that aspect, that there were 138 witnesses in virtually all the cases. There are about 3 cases which perhaps forms the subject matter for bail before your lordship. I am representing the accused in RC3 and RC5. There would be RC4 also, I think. But in all those cases, I can assure your lordship that the total number of witnesses would be around 138 to 140. 120 to 140, your lordship can take it as a approximate.
So unless sanction is granted, question of examination and trial would not start also.
Yes. Malad, moreover, kindly considers, even let us assume that if sanction had been granted, 140 witnesses trial cannot be finished even within that 3 or 4 years.
Yes. So what is your argument pertaining to the issue of non-granting of sanction and the nexus which has been sought to be?
Yes, Malad, we will come to that first.
Yes.
Let us place those things. Malad, now 17, the individual cases have been dealt with thereafter by my lord.
Yeah.
Malad, these 2 relate to the first one, Dr. Shubhirej Bhattacharya. They are my clients. They are 1 and 2. Item number 1 and 2.
Paragraph 17.
Paragraph 17 এর পর থেকে তো নিচ্ছে।
Page 20.
Paragraph 20, page 20, my lord.
Paragraph 18.
My lord, it's not 18, it's 17. At page 19, at the bottom, your lordship will get it. Now I will take up the bail applications and the next page.
Yes.
In reference, Dr. Shubhirej Bhattacharya and this. These are item number 1 and 2 before your lordship now. And your lordship can also get the RC numbers. It would be RC number 3 and RC number 5. May I place it?
Yes.
In CRMDB this, the petitioner seeks bail in connection with RC number this. In CRMDB this, the petitioner seeks bail in connection with RC 5 of 2022. Learned counsel for the petitioner submitted that the petitioner was arrested on September 19th, 2022. So today he is about 2 years, 2 months. More than that, coming to 2 years, 3 months. In connection with RC3 of 2022, although he was not named in the first information report, he was formally shown as an accused in the charge sheet dated this under section 120B 109 460, it would be 409, 109 467 468 471 of the Indian Penal Code, read with section 7 capital A 8 of the Prevention of Corruption Act 1988. Supplementary charge sheet dated March 15, 2023 was filed by CBI against 9 accused persons, including this petitioner, under sections 120B, 201, 420, 467, 468, 471 of the Indian Penal Code, read with section 7 and 8 of the Prevention of Corruption Act 1988. The petitioner was shown arrested in connection with RC 5 of 2022 on December 16th, 2022. The petitioner was the chairman of the West Bengal Central School Service Commission and was also the chairman in charge of the Southern Regional Office of WB Central School Service Commission. He resigned from the post of chairman of the commission in May 2018 and joined the post of vice chancellor in North Bengal University. Then your lordship will get the charges are there, paragraph 21, and our submission that he is in custody. At that point of time, perhaps it was when we had argued. Then other persons who have been granted bail in connection with this case. Then paragraph 23 is also a submission that he has cooperated and there was no financial benefit which could be traced out despite search of all his residences, all his bank accounts.
Important part আছে দেখো যেটা ওরা বলবে এই দেখো CBI till date has not been able to show any money till he is 46 years old. Tell us that the paper was ঠিক আছে এটা না আমি দেখে নিই একবার.
And in that, your lordship will find at page 22, the CBI proposes to examine 135 witnesses and rely on 382 documents as would appear from the relevant charge sheets. On merits, as also on the ground of delay in trial, the petitioner renews his prayer. The CBI vehemently opposed the prayer. Learned counsel for CBI had said that there is sufficient incriminating evidence against he was an integral part of the conspiracy to collect large sums of money from unsuspecting persons by promising to them jobs as teachers. He was also instrumental in generating forged appointment letters. CBI is not responsible. Then paragraph 25. The state government has not yet granted sanction for prosecution, which is required as regards some of the accused persons. In fact, the state government has neither granted nor refused to grant such sanction for prosecution. It is sitting tight over the matter. Considering the gravity of the offense alleged, the petitioner's prayer should be allowed. Rejected. Sorry. This was the submission of CBI. It was also submitted that further investigation is being conducted pursuant to orders of this court. So further investigation has again commenced. It may be necessary to interrogate the petitioner further if fresh incriminating material against the petitioner comes to light.
Next, paragraph 20. Very important.
Page 23. I find from the records that charges yet to be framed. Some of the accused persons are yet to be apprehended. The state government is sitting tight over the issue of grant or refusal of sanction to prosecute some of the accused persons to proceed against whom sanction of the government is necessary under the law. CBI has also not approached any competent forum for a direction on the state government to take a decision on the issue of grant or refusal of such sanction. Without such sanction, the trial is unlikely to proceed. Theoretically, the trial may be split up against the accused persons. However, given the nature of the offences as alleged in the present case, that may not be an appropriate procedure. Well, why this observation was made? Because according to the CBI, from 2022, they have been writing letters. Even that continued in 2023. One of our submissions was that the failure to grant or refuse sanction is an executive action on the part of the chief secretary. Now, for that, the CBI could have very well approached this honorable court for a necessary direction, which they did not do. And I gather till date they have not done so. That is why this observation by my Lord Justice Banerjee.
But there were certain observation, it appears from the records in earlier orders pertaining to the bail.
Yes. But thereafter, this bench segregated the two and said that the prayer for bail cannot be kept pending on those grounds, and therefore the prayer for bail was taken up separately, and this issue with regard to the pursuing the state for the grant of sanction was segregated. These two were segregated.
Please show me that one. That you continue. You show me that.
It is reflected in
Yes.
the order itself. ठीक है. Then paragraph 27.
So your argument is for the inaction of the executive towards grant of sanction. For the inaction on the part of the executive to grant of sanction, for which it is a ground for delayed trial. For that, your bail prayer cannot be affected.
Yes.
That's the basic. This is your argument. This is your argument. Your argument is, first of all, you cannot indefinitely keep me under in such facts and circumstances. Now, as regards the grant of sanction which has been taken by the CBI, your answer is that sanction or no sanction, that is an issue to be dealt with separately.
That was decided by this bench itself.
It was decided.
It was in an order which is reflected in this order. This bench had also held that since the prayer for bail cannot be kept pending in view of this issue, therefore the prayer for bail is being taken up separately, independently of that issue. And thereafter a date was also kept separately for the two by the earlier bench.
Yes.
Then paragraph 27. I also note that co-accused persons have been granted bail by the Honorable Supreme Court primarily on the ground of lengthy detention in judicial custody without there being any progress in their trial as noted above. I do not wish to dilate on the merits of the case or make any observation in this regard. However, I do not find, this is important, however, I do not find any significant difference between the footing on which this petitioner stands and the footing on which the other accused persons who have been granted bail stand. The basic charge against all the accused persons is to hatch a criminal conspiracy to defraud members of the public by meting out false promises of securing jobs for them as teachers against payment of money. Further, I have noted in the general discussion on criminal jurisprudence pertaining to bail that right to speedy trial is now recognized as a fundamental right of an under trial person under Article 21 of the Constitution. If the state or the court is not in a position to conclude the trial within a reasonable period of time, and under trial cannot be kept in incarceration for an indefinite period of time in negation of his fundamental right to personal liberty. After all, a fundamental principle of criminal jurisprudence of this country is that a person is presumed to be innocent until proved to be guilty before a competent court of law following due process. A person cannot be damnified by being detained in judicial custody for days together without being convicted. In the present case, the prosecution may or may not have strong incriminating material against the petitioner. I do not wish to make any comment on that, nor is the same necessary. Nobody stands in the way of the prosecution securing the petitioner's conviction by carrying the trial to its logical conclusion in accordance with law and with expedition. In the facts of the present case, however, there does not appear to be any possibility of the trial concluding on an early date. The trial has not even begun. The number of witnesses that the prosecution intends to examine, this is very important, Miller, the number of witnesses that the prosecution intends to examine and the number of documents that it proposes to exhibit would itself indicate that there is no likelihood of the trial coming to an end in the near future. The petitioner is a senior citizen. He appears to be suffering from various ailments. There does not seem to be any likelihood of the petitioner fleeing from justice. Investigation is complete. It is not the case of the prosecution that the petitioner is such an influential person that if released on bail, he is likely to tamper with evidence or influence prosecution witnesses. Given the offences alleged against the petitioner, the evidence against the petitioner would be largely documentary in evidence nature, which by now the prosecution would presumably have gathered. In view of the long detention of the petitioner in judicial custody, coupled with the fact that the trial has not progressed to any extent on the touchstone of Article 21 of the Constitution, I am inclined to allow the petitioner's prayer for bail. Insofar as further investigation is concerned, nothing in this judgment and order will stand in the way of CBI conducting the same or interrogating the petitioner further. However, in my opinion, further custodial interrogation of the petitioner is not warranted. Therefore, and then grants bail, and then your lordship can see from the third line from the bottom of the page, there was a direction that he should appear every day. This I am not.
Yes.
Then
Not to leave.
that the petitioner, while on bail, shall not leave the territory of the state of West Bengal without prior permission of this court, and shall report to the Superintendent of Police, CBI, SEB, Kolkata once in a week until further orders. Prior to his release on bail, he shall deposit his passport, if any, to the trial court. So allaying the risk of or the flight risk. Then Mr. Ashok Kumar Saha. ওনারটাও তো স্যার আছে না?
হ্যাঁ, একই ব্যাপার।
Paragraph 38 thereafter, if your lordship takes in respect of the other accused, whom Mr. Basu is representing.
Yes.
38. Learned advocate for the petitioner submitted that the petitioner acted as the assistant secretary from October 5th, 2015. In RC 3 of 2022, the allegations against the petitioner are under Section 120B, 428 of the IPC, read with Section 7 of the Prevention of Corruption Act. In RC 5, the allegations against the petitioners are under Section 417, 465, 468, 34 of the Indian Penal Code, read with Section 7 of the Prevention of Corruption Act.
Yes.
Paragraph 39. It was submitted that the petitioner is 70 years old. He is a retired public servant. Without prior sanction from the state government, CVI completed the investigation against the petitioner in violation of Section 197 CRPC and Section 17 capital A and 19 of the Prevention of Corruption Act 1988. Learned trial court has still not taken cognizance of the charge sheet dated this or the supplementary charge sheets dated this and this, which implicate the petitioner. Without taking cognizance, remanding the petitioner to custody beyond the statutory permissible period is illegal. In connection, reliance was placed on Section 309, subsection 2 of CRPC, the material portion whereof reads as follows. If the court, after taking cognizance of an offence or commencement of trial, finds it necessary or advisable to postpone the commencement of or adjourn any inquiry or trial, it may from time to time, for reasons to be recorded, postpone or adjourn the same on such terms as it thinks fit for such time as it considers reasonable, and may by a warrant remand the accused if in custody. Well,
What only after taking cognizance.
Yes. And prior to, with the leave of Mr. Basu, I'll just.
This is exactly what I submitted by me, my lord, without taking cognizance. After the end of the investigation, when the charge sheet is filed, court has no power of remanding the accused to custody without
But
taking.
they are filing supplementary charge sheets, continuing to file.
But then
No cognizance.
no cognizance was taken. The court has to take cognizance of the offence. Only then, Lord, after investigation, court can remand the accused to custody after refusing his prayer for bail. Otherwise, court can't do that.
Well, I gather Mr. Basu will take your lordship to 167 of the CRPC also, where it says after the expiry of the period of 90 days, the learned magistrate loses his power to further remand the person to custody.
So this is 167, but after the investigation, 309.
So after 90 days, he has no other option to either release him on bail or act under 309 if he has taken cognizance. In this case, he has not taken cognizance. So after 90 days, expiry of 90 days, there was only one path which was open to him, was to act under in terms of section 167(2) to grant him bail, because he loses the power to further remand.
Yes. Yes, Mr.
Paragraph 40, it was further submitted that sanction has still not been granted by the state government. Therefore, learned trial court has not taken cognizance of the alleged offence. The petitioner is in custody for more than 2 years. There is no possibility of the trial beginning on an early date, let alone an early conclusion of the trial, on the ground of breach of the petitioner's fundamental right under Article 21 of the Constitution. The petitioner should be enlarged on bail. Then the CBI had strongly opposed the prayer for bail and said that there was sufficient material implicating the petitioner and the offense was of a grave nature and that he may tamper with the evidence. Then paragraph 42. I find that the petitioner is in judicial custody for almost 2 years and 3 months. Trial has not begun. In fact, cognizance of the alleged offense is yet to be taken by the learned trial court. The prosecution intends to examine more than 100 witnesses and proposes to exhibit a large number of documents. CBI has not taken any legal steps for obtaining sanction to prosecute the accused who are retired public servants. It is anybody's guess as to when the trial will begin or end. By the present judgment on order, I have granted bail to a co-accused, namely...
Mr. Ganguly, this argument of yours that without taking cognizance you cannot remand him as per, this is applicable in respect of all the petitioners.
Yes. Yes, to that extent, yes.
Obviously. Yes.
All this.
Yes.
Then paragraph 43. By the present judgment and order, I have granted bail to a co-accused, Dr. Shubhiresh Bhattacharya, against whom the charges are graver. For the same reason for which I allowed the bail prayer of Dr. Shubhiresh Bhattacharya, I am inclined to allow the instant bail petition. In other words, primarily on the ground of inordinate delay in the progress of trial, and considering that this petitioner stands on a better footing than Dr. Shubhiresh Bhattacharya, who has been enlarged on bail, I allow this application. Same conditions, Millard.
Yes.
Then at page 29, your lordship will get Dr. Kollanmoy Ganguly. Millard, in this, he was praying for bail in connection with RC3. He had already been granted bail by this honorable court in RC5. What is the?
So this Dr. Ganguly.
Yes.
Granted bail in respect of RC5.
RC5 order dated is 29/11 to 2023 and CRM 4100 of 2023.
What is the date you said?
29/11 2023.
All right. Yes.
He is in item number 5, my lord. The petitioner was appointed as the president of the West Bengal Board of Secondary Education in the year 2016. He retired as the president of ad hoc committee of West Bengal Board of Secondary Education on June 24th, 2022. RC5 was registered by the CBI against several accused persons, including the petitioner. In connection with that case, the petitioner was arrested on September 15, 2022. The case in connection with which the present bail application has been filed, being this, was registered by CBI against several accused persons, including the petitioner, under section 120B, 420, 109, 467, 468, 471, and section 77A, 8 of the Prevention of Corruption Act. In connection with that case, he was shown arrested on November 29th, 2023, the date on which this honorable court granted him bail In the afternoon, he was shown arrested in connection with RC3. According to the CBI, the prayer was there a few days back, previous to that.
On 29 November itself, he was granted bail in RC5.
My lord.
Yes.
I'll take your lordship through the other judgment afterwards. My lord. Paragraph 48. It was submitted on behalf of the petitioner that he has been granted bail in connection with RC5 by this court by order dated November 29th, passed in this. The allegation against him in the instant RC number this are identical with that in RC5. Hence, he should be granted bail in this case also. Then others were granted bail. Then 49, it was further submitted that the arrest of the petitioner in connection with the instant case was mala fide. His bail prayer in connection with RC5 was allowed by this court in the first half on November 29, 2023. On that very date in the second half, the CBI obtained an order from the learned trial court for showing the petitioner as arrested in connection with RC3. It was still submitted that till date, the CBI has not been able to show whether or not the petitioner is the recipient of any ill-gotten money. No property belonging to the petitioner has been attached. He was not named in the FIR. He is not the primary accused. The appointment letter was issued on the... I'll take your lordship through those factual aspects afterward. But one thing, Malad, in the interregnum, this ED in a PMLA complaint had implicated him. And thereafter, after the complaint was filed and cognizance was taken, he was produced from custody and thereafter was granted bail in that case also.
Is Kullan
Malad.
Yes.
Then Malad 52 is
That
their
happened
opposition.
subsequently.
Malad?
This issue, this
Yes.
This has been subsequent.
Subsequent to this order also.
Order.
No. I think during the period when the hearing was
Judgment
completed
reserved.
and the delivery of the judgment, in that period, he was...
First and second.
Hmm?
First and second.
No, PMLA, sir.
So that couldn't be brought to the notice of the honorable judges. After the judgment was...
My junior who was assisting me is not here today. I don't remember the exact date. That's why. Then my lord can take it up from paragraph 53. Page 32.
Yes.
The petitioner is now in custody for almost 2 years and 2 months. He is 73 years old. He also appears to be suffering from various ailments. I find that he is similarly circumstanced as a co-accused person, that is Subhiresh Bhattacharya, who has been granted bail by this very judgment. Hence, on the grounds on which I allowed the prayer of Dr. Subhiresh Bhattacharya, I am inclined to allow the present bail application. That is the ground of lengthy custodial detention of the petitioner, coupled with the fact that the trial has not progressed at all, thereby abrogating the petitioner's fundamental rights to personal liberty and speedy trial as enshrined. And the bail was granted on the same conditions. Allowed হয়ে গেছে।
Now Kaushik Ghosh.
No, Kaushik Ghosh has been, his bail was affirmed by...
Part A.
In Sheikh Ali Imam and Mohammad Shahid Imam, they were also allowed by the Honorable Second Judge.
Part B, page 88.
Then Shanti Prasad Sinha is from paragraph at page 38. Apna to sir. Mr. Mukherjee is representing these. They are 6, 7, and 8. Items 6, 7, and 8.
No.
7, 8, 9.
Oh, 7, 8, 9. I'm sorry.
And 6 is Partho Chatterjee.
6 is you are representing.
No, 6. I am representing 5. Kollanmoy Ganguly.
Oh, 8, 6, 7, 8, 9, Mr. Mukherjee.
Yes, 6, 7, 8, 9.
Yes. So Kaushik Ghosh,
Milord,
Sheikh Alam,
kindly turns
Mohammed
to page
Shahid,
88. 88.
88. Yes.
Part B, your lordship will get Kaushik Ghosh,
Oh, I see.
Sheikh Ali Imam and Shahid Imam, Subroto Samanto Rai in two cases, and Chandan Mondol.
Very good. Now you will come to Shanti Prasad.
Page 38, Milord.
38, para 73 onwards.
Then kindly takes it up from paragraph 75.
Yes. 75, yes.
RC number 3 of this was registered by CBI for investigation on the basis of an order dated this passed by the learned judge of this court in WPA number this. In the FIR dated April 7, 2022, filed by CBI, it was alleged that the petitioner, in conspiracy with other unknown public servants, dishonestly extended undue advantage to some candidates in the matter of appointment of assistant teachers in class 9 and 10. First state level.
Ganguly, I interrupt. The 7th April 22 order, this was appealed against, na, before Justice Talukdar. Was it this order, which ultimately went to the Supreme Court?
Yes.
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 Justice Subroto Talukdar and
Justice Talukdar with Justice Banerjee, Lopita Banerjee. Yes.
Then 76. The petitioner was arrested on August 10, 2022 in connection with RC number 5. Since then, the petitioner is in judicial custody. Since he was not shown arrested in connection with RC3, he surrendered before the learned trial court on September 9, 2022. In connection with RC number 4 of 2022, the petitioner was shown arrested on March 24, 2023. The petitioner submitted that he joined the West Bengal Board of Secondary Education as secretary in 2011. He retired from that service in 2012. On August 1st, 2018, the petitioner joined the School Service Commission as advisor for a period of 6 months. Such appointment was extended from time to time. It was submitted that although charge sheet against the petitioner was submitted on September 30th, 2022, till date, the learned trial court has not been able to take cognizance of the offences alleged for want of sanction to prosecute from the end of the state government. Without taking cognizance, further remand of the petitioner beyond the statutory period is illegal. In this connection, learned counsel, well, the same 309.
Yes.
Then 79. Learned counsel further submitted that the petitioner is in judicial custody for over 2 years without there being any progress in the trial. On the touchstone of Article 21 of the Constitution of India, the petitioner should be released on bail. Co-accused standing on the same footing as the petitioner have been enlarged on bail by the Honorable Supreme Court as also by this Honorable Court. In particular, learned advocate referred to co-accused persons Prashanna Kumar Rai, Dr. Kollanmoy Ganguly and Abdul Khalek and drew to our attention the orders granting bail to these accused persons. Opposing the petitioner's bail prayer, learned advocate for CBI submitted that the petitioner is the prime accused. He engineered the entire scam in conspiracy with the other accused persons. There is clinching, incriminating evidence against the petitioner. It is not for any laches on the part of CBI that the trial has not proceeded. The state government is sitting tight over the issue of grant/refusal of sanction to prosecute. Given the seriousness of the alleged crime, the petitioner's prayer should not be allowed. I have given my anxious consideration to the rival contentions of the parties. The petitioner may be the prime accused. The prosecution may have a very strong case to secure his conviction. Nobody stands in the way of the prosecution doing so. However, one cannot be oblivious of an under trial's fundamental right to personal liberty and speedy trial. In fact, the graver the offense, the sooner the trial should be concluded, so that if the accused person is found guilty following due process of law, he can be punished. No accused person can be indefinitely detained in judicial custody without there being any progress in the trial at all. That would amount to complete abrogation of the dual fundamental rights to personal liberty and speedy trial, which every accused person has. These rights are paramount and must prevail over all other considerations. Further, given the offences alleged, that is, cheating members of the public by issuing forged appointment letters in the post of teachers against payment of money, the prosecution evidence would be largely documentary in nature. Investigation is complete. By now, the prosecution must be having all relevant evidence in its possession in view of the aforesaid and in the light of the discussion on the principle of governing stroke rejection of bail as recorded in the earlier part of this judgment, taking note of the long incarceration of the petitioner for more than 2 years and 2 months, coupled with zero progress in the trial, I am inclined to allow the petitioner's prayer for bail. And the same conditions were granted. Your Lordship can, Subroto Samanto Rai was granted, page 42. He was granted bail by both the honorable judges.
Yes.
Well, next is Partho Chatterjee at page 45. If your Lordship permits Mr. Mukherjee to take.
Sorry. The petitioner seeks bail. Page 45, para 96. The petitioner seeks bail in connection with RC 5 of 2022, dated May so-and-so, registered by the CBI under section so-and-so. Learned advocate for the petitioner submitted that the petitioner was appointed as the minister in charge of Higher Education and School Education Department, West Bengal government, after the assembly elections of 2016. He is a septuagenarian and suffers from various old age related ailments. Advocate relied on so-and-so. It was further submitted that the prime accused is Shantiprata Sinha, who was the convener of the supervisory committee constituted for supervising, monitoring, and guiding the WB in connection with the pending recruitment process. The allegation against this petitioner is that he approved the constitution of such committee in violation of the provisions of the School Service Committee Act. The petitioner was not named in the first information report. During the investigation of RC5, the enforcement case in ECR case dated 24th of June 2022 was registered by the Enforcement Directorate, and the petitioner was arrested on July 23 by the official of Enforcement Directorate from the residence for his alleged involvement in the offense of money laundering. After completion of inquiry, a petition of complaint was filed by the Enforcement Directorate before the jurisdictional court and was registered as ML case number so-and-so, arranging the petitioner as an accused. It was submitted that when the petitioner was in custody of the Enforcement Directorate, he participated and cooperated with RC5 of 2022. However, while he was in custodial detention with ML case number 13, well, that is the money laundering case number 13 of 2022, on September 16, 2022, the petitioner was produced before the trial court in connection with RC case number 5. On a petition moved by CBI, the learned trial court allowed CBI prayer to show the petitioner as arrested and also allowed the prayer for remanding the petitioner to CBI's custody. The petitioner was in CBI custody from September 16, 2022 till September 21, 2022. On September 22nd, the petitioner was remanded to judicial custody. Since then, he's in jail custody. Learned counsel submitted that investigation is complete. Several charge sheets have been filed. No incriminating material has been found against the petitioner. He is in custody for more than 2 years. Trial has not begun. The prosecution intends to examine 137 witnesses and exhibit more than 200 documents. Now, even if we take it, 2 witnesses per day, then also 6 months, roughly. More than 200, there is no possibility of another conclusion of the trial. On the ground of breach of petitioner's fundamental right to personal liberty and speedy trial, he should be granted bail on such conditions. Now, the objection. Learned advocate for CBI vehemently opposed the petitioner's prayer for bail. He submitted that the petitioner is the mastermind behind the SSC camp. He illegally removed Dr. Sharmila Mithro from the post of chairperson of so-and-so, violating the provisions of Section 5 of the Act. He appointed Professor Soumitra Sarkar as the new chairman of so-and-so on the basis of handwritten biodata of Professor Sarkar. He appointed Dr. Shanti Prasad Sinha as advisor so-and-so. He forced Professor Sarkar to resign from chairmanship on finding him to be an unwilling party to the fraudulent activities in the connection with the recruitment scam. Professor Sarkar had issued a show cause letter to the co-accused. These which we are just reading out, when we go specifically into the bail application, we'll try and show to your lordship that he was not in any way involved. Professor Sarkar had issued a show cause letter to the co-accused persons. Dr. Sinha, in connection with the issuance of forged recommendation letters after expiry of the concerned panel. Professor Sarkar was replaced by co-accused Ashok Kumar Shah in violation of the provisions of 4 of the Act. The petitioner used to send various lists of ineligible candidates through one Praveen Kumar Bandyopadhyay, who had worked as SD to the petitioner from 2014 to 2021. Probir used to forward such lists to the concerned official of the so-and-so so that the process of appointment of such candidate could be taken up by the commission and the board. It was further submitted that the co-accused Dr. Shubiresh Bhattacharya received various lists of candidates from the Nagtala resident of the petitioner. At the said residence, there was an office on the ground floor where lists of candidates were updated. Both Prasanna Kumar Rai, on bail, Pradeep Singh, bail, two of the accused persons were frequent visitors to the petitioner's Nagtala residence. Dr. Shanti Prasad Sinha and Dr. Shubiresh Bhattacharya also used to frequently visit the petitioner at his Nagtala residence. The lists of candidates were handed over to the said officials of so-and-so for due processing in order to extend undue benefits to the concerned candidate by issuing recommendation and appointment letter. The list of candidates along with the money, excluding the commission of Prasanna Kumar Rai, were handed over to the petitioner at his Nagtala residence. But no recovery. The list of candidates were then handed over to Shubiresh Bhattacharya by the petitioner for placing such candidates on the panel and issuing recommendation letter so that the appointment letters could be generated for such candidates. It was further submitted that the petitioner was instrumental in introducing the West Bengal Board of Secondary Education Appointment, Confirmation, Conduct and Discipline of Teachers and Non-Teaching Staff Rules 2018, which made West Bengal Board of Secretary, in short, the central authority for issuing appointment letters for both teaching and non-teaching posts in government-aided sponsored school in West Bengal. Due to criminal conspiracy involving the accused person, namely Dr. Shubiresh Bhattacharya, Dr. Kallanmai Ganguly, and the petitioner, the 2018 rules were illegally given retrospective effect by making the same applicable for a process of recruitment which started in 2016. It was then submitted that all crucial decisions like appointment to the statutory post, secretary, president, chairman of so-and-so were finally approved by the petitioner. He was the kingpin, so as to say. Learned advocate for the CBI submitted that due to the heinous nature of the alleged offense and the availability of enough incriminating material against the petitioner, his prayer for bail should be rejected. Although I have noted the points urged on behalf of the CBI in opposing the petitioner bail prayer, the same pertains to the merits of the case. I am not inclined to express any opinion on the strength or otherwise of the prosecution's case. I find that the petitioner is in judicial custody from September 22nd, 2022. That is for more than 2 years and 1 month. Learned trial court has yet not taken cognizance of the alleged offences for want of sanction to prosecute from the end of the state government in respect of some of the accused persons who are retired public servants. However, I understand that sanction to prosecute has been granted by the competent authority so far as the petitioner is concerned. In any view of the matter, it is highly improbable that the trial will begin on at an early date. Even assuming that the trial was to begin in the near future, an early conclusion of the trial is clearly not possible, given the number of witnesses that the prosecution proposes to examine and the number of documents that the prosecution intends to exhibit. The prosecution may have an iron cast case against the petitioner for securing his conviction. Nobody stands in the way of the prosecution to do so. However, one cannot be oblivious of the fundamental right to personal liberty and speedy trial, which every under trial has such. Such right is paramount and must prevail over all other considerations. It was also urged on behalf of CBI that the petitioner being an influential person, he is likely to tamper with the evidence or influence witnesses if released on bail. I do not find much merit in such contention. That part, para 12, your lordship was saying regarding the witnesses, your lordship was saying, that has been answered by Justice Banerjee. I do not find much merit in such contention. The petitioner is no more in a position of power. Given the nature of the charges, the prosecution evidence would substantially be documentary in nature. Upon completion of investigation, the prosecution would be having in its possession all relevant evidence. I also do not find any real possibility of the petitioner fleeing from the course of justice. He has deep roots in the society. Without making any comment on the merits of the case and solely on the ground of prolonged incarceration of the petitioner, without there being any progress in the trial, which has infringed the petitioner's fundamental right under Article 21, I am inclined to allow the petitioner's application for bail. I may note that there is considerable similarity between the allegation made against this petitioner and the allegation that were made against the appellant in the case of so-and-so, wherein the Honorable Supreme Court granted bail. Right? Then, therefore, the accused petitioner, namely Partho Chatterjee, be released on bail of so-and-so. RC 5, cannot 5 though. It should be 5 there. So the bail was granted, Malad. Now, Malad, I am not skipping Chandan Mandal and others, Malad. That's Malad is the concluding part. Malad, page 55.
Yes. Para
127.
Yes.
Before party, I would like to add a few concluding words which would be relevant to all the bail applications which I have considered above and allowed. The crux of the allegations against the petitioners before us is that they hatched a criminal conspiracy to defraud members of the public, and in particular those persons who aspire to be teachers in government educational institutions. They offered jobs to undeserving, ineligible candidates against payment of money. They forged appointment letters. They collected huge sums of money from the concerned candidates. Indeed, if such allegations are ultimately proved to be true at the trial, the same would establish that the petitioners have committed a grave and heinous criminal offense. They should then be appropriately punished. However, the law of a country says that a person accused with commission of a criminal offense will be presumed to be innocent till he is found to be guilty and convicted by a competent court of law. An accused person may be detained in custody if in particular circumstances, the same is necessary for proper conduct of investigation. However, once investigation is complete and charge sheet has been submitted by the investigating authority, only in very few exceptional circumstances, continued incarceration of the accused would be justified. One such circumstances may be the criminal history of the accused persons. He has criminal antecedents. It is found that such person is a habitual offender, a serial killer. It may not be prudent to set him at large even after completion of investigation. Societal interest would warrant that he be detained in prison. Again, if there is a real fight risk, the accused person is likely to abscond a release, bail may be justifiably refused to him. Similarly, if the accused person, if set free, is likely to tamper with evidence or intimidate prosecution witness, his bail may be refused. However, none of these exceptional circumstances, in my opinion, apply to any of the petitioners before us. It is highly unlikely that the petitioners will be in a position to commit similar offense if enlarged on bail. As regard tampering of with evidence, in the present case, the evidence relates to documents like fake appointment, recommendation, which have already been seized by the investigating authority and or statement of public servant. It is highly improbable that the release of the petitioner from judicial custody will in any way hamper the trial. I have also gone through the order dated November so-and-so, passed by the coordinate bench whereby bail was granted to one of the other petitioners in RC5, namely Dr. Kollanmai Ganguly. The coordinate bench applied the tripod test of likelihood of the petitioner absconding, possibility of the petitioner committing similar offences, and probability of the petitioner interfering with the progress of investigation or trial. The bench also observed that to continue under trial detention of the petitioner merely on the gravity of the offence when the other requirements of absconding tampering, that is the tripod test, does not justify such end, would in our estimation amounting to punishing the accused under the garb of under trial detention. It must also be borne in mind that the offences, even if proved, would not attract life imprisonment, mandatorily life imprisonment. Keeping an under trial in incarceration for an indefinite period of time would tantamount to pre-trial conviction. That is unknown to our criminal jurisprudence. The allegation against an accused may be extremely grave. Still, the same have to be proved in a duty-held trial before a competent court. An accused person cannot be detained in judicial custody for a long period of time merely on the basis of allegations which are yet to be proved. The fundamental right of a person, including an ultra trial prisoner under trial, as enshrined in Article 21, includes his right to personal liberty and speedy conclusion of trial. Such fundamental right is paramount and overrides all other consideration in a criminal trial, irrespective of the nature and gravity of the charge. If the state or the legal system does not have the means to conclude a criminal trial within a reasonable period of time, the prosecution should not oppose the accused person's prayer for bail other than in exceptional circumstances, some which I have discussed above. Right to personal liberty is precious and perhaps the second most important fundamental right after right to life. Noting CBI's submission that further investigation is in progress as directed by this court, I make it clear that nothing in the judgment and order shall prevent CBI from carrying out with such investigation. If fresh material against all of the petitioners in this bail petition is unearthed in the process of such further investigation, CBI will be at liberty to further interrogate all such petitioners if it deems necessary to do so. The concerned petitioners are directed to fully cooperate with the investigation officer in that regard. However, further custodial investigation is not necessary in my considered opinion. In fine, all the bail applications are allowed. But subject to correction by Mr. De, my lord, there is one thing here where the CBI has said that they have been given permission by this court to carry out an investigation. But what little I am aware of is, my lord, the Supreme Court was hearing a matter. Then Supreme Court remanded it back to the Chief Justice, saying you put up a division bench which will hear the petition pertaining within 6 months, mainly pertaining to Section 65B of the Evidence Act, pertaining to the documents
of the
evidence. So, in that case, Justice Devanshu Bhausha and Justice Rashidi was pleased to pass an order directing them that they should finish the investigation within April 2024.
Without sanction, that cannot be done.
That was done. So that also included, which has been stayed by the Supreme Court, by the persons who were beneficiary of such order. So that was fixed before Justice Chandrachud had appeared, but it is now gone to Justice Khanda, but nothing has happened. There's only a stay on the arrest of these persons, which was to be
with an undertaking.
So this is what, not the bench of Justice Banerjee or Justice Sinha Roy. It was by Justice Bhausha and Justice Rashidi, subject to corrections by Mr. D.
Yes.
Right, Malad? Now, Malad, you have permission.
Make pleasure,
Justice
But your lordship find the judgment of Mr. Arijit Banerjee in all the cases where the petitioners prepared for bail. His lordship essentially referred to Article 21 of the Constitution of India and also referred to the allegations leveled against the petitioners and also came to the conclusion that the proof of the prosecution case is based on documentary evidence and all the documents are in custody of the CBI. So the question of the accused person being influenced and influencing the witnesses does not arise. This has been repeatedly not observed in the order of Justice Arijit Banerjee. Now, I'm come to that. Now, my Lord Mr. Arijit Banerjee, with regard to the length of detention suffered by each of the accused persons, applied and in my humble submission correctly the concept of Article 21 of the Constitution of India. Now, Super Justice, the order of Justice Apurva Sinha Roy is concerned, but with great respect to his lordship, Lord, there is no reference to Article 21. No reference whatsoever. No reference under Article 21 or to Article 21. His lordship says that these persons are influential. If they are released on bail, they will influence the witnesses. In doing so, again, Lord, with great respect to his lordship did not consider the view expressed by my Lord Mr. Arijit Banerjee that this is a case based on documentary evidence. So, in my humble submission, the view expressed by Justice Apurva Sinha Roy is absolutely contrary to the prosecution case and the requirement of the proof of the prosecution case on the basis of documents. If Lord will look into that order, Lord will find, although Lord.
Yes, in two paragraphs, Justice Banerjee has referred.
Yes.
Primarily, it is documentary evidence.
Documentary evidence.
Tampering does not appear since those have been seized.
Seized and in the custody of the CBI. Lord, that in my humble submission. Apart from
Mr. Basu and Mr. Mukherjee is there. What are the parameters towards ascertainment of influence? What are the parameters? Suppose this Mr. Partho Chattopadhyay had been a cabinet minister. Now today
he's a nobody. He's a nobody today.
No.
2.5 years in custody.
We are saying what I am asking is that Justice Sinha Roy primarily, as you said, that he proceeded on the basis of influence that might be cast. Now, what are the parameters
Lord,
to determine?
if I may say so,
this influence may
Lord,
come upon
if I may say
examination of
so,
witnesses
without,
also.
Lord, if I may say so, without affecting the ego of any person, since the commencement of our criminal jurisprudence, there had been no concept of how the witnesses can be influenced by a person. No concept at all. But whenever the court is not inclined to grant bail to a person, especially not in cases where there is a political background, the court will always say that the person concerned is an influential person and he will influence the witnesses. This is
subject to correction in the bail of Mr. Chidambaram. Supreme Court dealt with this one paragraph, if I am not wrong.
One paragraph.
Which says that no contemporaneous material was produced to justify that influence would be there.
That's right.
So what is that contemporaneous document?
That is the conduct of the person concerned with regard to his professional activities, with regard to his personal activities, his social interaction, so on and so forth, and his activity pursuant to the commission of the offense.
This question to show this nexus between the state and the accused, what document have they produced?
No, nothing they have produced. Nothing they have produced. It's clearly
one argument on their part certainly would be that irrespective of the fact that it is on documentary evidence, at the time of examination of a particular person, he may be influenced by one particular
person. How a witness who examines...
That is why we are asking.
That's what I'm saying. But I can understand what a witness speaking about a fact. Fact. Nothing related to the document. But how can a witness be influenced when he is giving his evidence with regard to the contents of a document? He will definitely be declared hostile. And secondly, Lordship knows Section 62 of the Evidence Act. So what the documentary evidence is concerned, it will always override the oral evidence. How can a witness not take away or go away from the contents of a document when he is being examined in court with regard to the contents of a document?
He may not appear also, Mr. Basu.
So that's a different thing altogether. He may not appear. Court has ample power to enforce the attendance of a witness, even if he does not. But if he does not appear, the persons who are conversant with his handwriting, they will be examined and they will speak with regard to what appears
In the
what
document.
appears in the document. There is a law with the evidence, sir.
So anticipation with regard to such alleged tampering influence of witness cannot occur at this juncture.
No, certainly not.
This is
Grateful.
your
Yes,
point.
right, right,
This
great.
is my topic.
Malad, there is another issue. I'm going to hold it. Malad, there is another issue subject to correction.
I am one. You people are 3 and 4.
No, my lord. We are privileged that we are appearing before your lordship, my lord. No, my lord. Oh, assisting your lordship, my lord, to come to a.
Yes, Mr.
My lord, I'll just say one thing, my lord. If your lordship, I think your lordship has gone up, at least reasonably gone through the order of Justice Sinha Roy. My lord, let me say this. 482 power cannot be utilized to direct a state government to grant sanction. The Honorable Supreme Court has specifically said that the High Court cannot direct the authorities to grant sanction. And fortunately, unfortunately, it's my elder brother's judgment in Supreme Court.
No, why unfortunately?
No, but what is unfortunately for CBI?
He was
Unfortunately for CBI.
no, he was a teacher for all of us.
Yes, yes.
So, my lord, what he has very well said, a sanction is an independent assessment of the evidence in respect of what the CBI or others can state about it. So the High Court just can't grant or direct the government to grant sanction.
Concept of difference between judiciary and executive.
Executive. Because of the independent 1997 Supreme Court Mansukh Lal Vittal Das Chavan, where he has specifically said nobody can direct anybody to grant sanction.
But can direct to take a decision at
That is true. That is true. Your lordship right.
Absolutely.
Well, to either reject it or allow it.
Citation you said just
1997 CRLJ. I'll just give you that. Mansukh Lal Vittal Das Chavan versus the state of Gujarat.
Yes.
Justice, it is AIR 1997 Supreme Court.
Yes.
34,000 equivalent to 1997 within bracket 7 SCC
Yes.
622. Delivered on 3rd of September 1997. Justice Mukherjee and Justice Hagir Ahmed.
But Justice Sinha has said that in view of the earlier orders, observations of which were not challenged. That is
By who?
I was
Well, who would have challenged that? The CBI should have challenged that. The CBI should have taken necessary steps. Well, your lordship thinks about it. The prosecuting authority is the CBI. The CBI asks for sanction. So they should go and see that the sanction is granted. They did it for my client Malad and Mr. Ganguly's and my client Malad, Dr. Chatterjee. They got the sanction from the governor. So once they had got the sanction from the governor, same way they should have prosecuted or what should I say? They should have seen that the sanction was granted.
If it not granted, they put a plate for
Writ of mandamus from the writ court.
Absolutely.
Because Malad, this your lordship will please see.
It was incumbent upon them to proceed further.
When they asked for it.
For that I cannot suffer.
Absolutely. Absolutely. We can't suffer for an act of the CBI. Malad, only one thing. If a lordship only at one
His judgment, Mr. Mukherjee was not replaced before the court, 97.
No, we didn't because that part was never heard by the bench. It was never contemplated also.
We have cited the judgments of the Honorable Supreme Court.
Only Article 21.
That despite the seriousness of the allegation, even in heinous crimes, heinous offenses, If the person concerned is in custody for a long period of detention, long period, there is no possibility of commencement
That
of
is
the
Najib.
Najib and other. There are 4 judgments we have.
Yes, and your argument was on respect of Balaji also, where Supreme Court had intervened.
He was a minister also, my lord. My lord, tomorrow we'll start with the individuals.
Individual, Mr. Mukherjee, subject to correction, I am to determine that which view is the proper view.
That is why, my lord.
So you want to take me to the to what?
Well, what was placed before the courts?
Pardon?
What was placed before the court? My lord, one petition, my lord, bail application which were put before the court.
Yes.
Whether your lordship will hear us on the individual liability of those persons.
No, subject to correction which may arise. We have been, the Chief Justice has asked me to consider that which view is the right.
I am telling you, Lordship, as per the
Judgment.
interpretation of law
Under
which is not
390.
the authority of the Honorable Third Judge, your Lordship may agree with the view of one of the
I
Honorable
cannot give a
Judges.
third opinion.
No, I'm telling you,
There cannot
Lordship.
be a third
Your
opinion.
Lordship may
Cannot be opinion.
agree with the view of one of the Honorable Judges or may disagree with both the Honorable Judges and express your Lordship's own independent opinion.
And that will go to a 3 judges bench.
And that will go to the Honorable Judges. And
Three
they-
judges.
Is that Justice Sanjeev Banerjee passed an order, some Shibani textiles or something like that. Where if it is what has been relegated is only one prayer.
You want to see the judgment that we have given to your Lordship.
Yes.
1997 Supreme Court cases criminal.
No, you are saying that even if I do not
Agree with either.
agree with either of the view, then what is left? What third
No, your
opinion is
Lordship
left?
independent view. According to Supreme Court.
So what I will say in a bail application, what other view I can take?
Either allow or reject.
I can allow or reject.
The reasons
But
may
I
be
cannot take any.
Well, your reasonings may be different.
Correct.
Your reasonings may be
No,
different.
naturally, if I support any one particular view, I have to give my reasons for that.
Correct, correct.
Because my order may also be under challenge before before a superior forum.
Well, the only thing is that if your lordship perhaps agrees to the view of grant of bail, your lordship, in addition to Article 21, may also be of the view that it should be granted for other reasons.
That you show me with judgment.
So
here.
that is why each of us. Oh,
Acha, I get your lordship. No, that I get your lordship.
on your lordship's as to how your lordship can decide.
Malad, that,
No,
Malad, only one
bail
paragraph.
given or bail denied. So what has been told to me is that which view is proper? Bail denied is proper or bail
bail
granted is proper?
Allowed.
Whichever view is followed.
Malad,
that
your
will be-
lordship differed from Justice Gupta.
So that I
No, Malad, your lordship had passed an order on that. So, Malad, may I just want your lordship to please come to one paragraph, Malad. It's Justice Sina Roy's judgment, Malad. Paragraph 9.
I am still to learn from you senior counsels. We are
No, Malad, don't say that, Malad. It's a privilege. I told your lordship. Paragraph 9. At page 77. अरे समझ इतना पूरा text है ये.
yes,
Well, paragraph 9 at the bottom.
page 77.
7.
Why this is para 9? This is part. This is
Sir, page 77, para 9. So, no?
My Lord Justice Sinha's order. Yes.
Yes.
Page 70. Yes.
Another important aspect which should not be lost sight of us is that can we allow the state government to interfere with the judicial proceedings indirectly by not taking any decision on the issue of sanction and thereby stalling the entire judicial proceedings and eliminating its confidence to obtain bail on the plea of delayed proceedings?
That weighed with the learned judge.
Yes. This is what I'm trying to tell you. That's profitable over 82 principle. Then, my lord, what my lord had to.
Mr. Mukherjee, when you are showing me that,
Yes, sir.
just I found another.
Which paragraph, my lord? Justice Bakshi's orders.
Yes.
Yes. Well, it's starting at page 74. No, 72.
Page 68, paragraph 9. What do you say about this?
We hope malign influence of an accused person who held prominent posts in public administration, including one who was a former, does not have anything to do with the recalcitrant attitude of the Chief Secretary.
Borrowing the issue from there, Justice Sinha has observed.
Mala, the word is we hope. Justice Bakshi starts with the word we hope. Mala, if that was true, then why would Dr. Chatterjee be granted a sanction?
Now, is that not a sufficient presumption to show that there is a possibility of tampering, influencing the witnesses?
Well, the Chief Secretary is not a witness.
Not sanction. Sanction has been, they are under an obligation to give a decision. On one hand, they are not coming up with a decision of rejection or grant, which would enable the aggrieved party to move higher.
So, my lord, the only reasoning as my lord is trying to impress upon us is my influence.
I am not.
My influence. My influence.
What is the connection
what Justice Sinha has considered?
Yes, but he did not consider the last part also. This was the basic thing. Thereafter, my lord,
vis-a-vis, you kindly read. Subject to correction, I think this weighed with the Justice Sinha in passing the order.
that is true, but he did not go to the subsequent orders of Justice Bakshi.
Where is that from?
Well, please comes to instill confidence. Well, it comes to page 72, para 6, C.
72.
Well, when the AG appeared.
Yes. Grant of sanction is the stepping stone towards commencement of trial.
That's what they have said. The CBI. Once you get a sanction, you have to go proceed with it. Take lawful steps to see that the sanction is granted or rejected.
Why the Chief Secretary is not taking a decision?
Okay. Well, how can I say now, Malad, with due respect, Malad, even though that will not apply to us?
It seems like willing to win, willing to wound, yet not to strike.
Well, that's where the problem is, Malad, because.
But if your lordship
somebody must have appeared for the state, na?
Advocate General, Malad.
Learned advocate.
Learned advocate himself appeared.
Along with the government pleader.
So nobody wants to appear on behalf of the state here.
If a lordship calls for them, they'll come.
No,
there are orders.
They are parties to it. They are parties, na? State is a party.
75.
Well, kindly see page 75.
Yes.
In view of the submissions we direct.
75.
73 first. 73 first of all. Order dated 3rd of May 24.
Yes.
In view of the submission, we direct that the prosecuting agency, that is CBI.
Page 75.
3.
In view where you are getting
last paragraph, 2.
Yes.
In view of the submission, Mr. Ganguly had said it at the outset. Then, my lord,
CBI to submit report with regard to appropriate sanction.
With regard to the petitioners and the other accused. Then the report shall indicate
whether the appropriators have been approached by the CBI for grant of sanction or not. My lord, with this, your lordship reads Mr. Ganguly's statement.
Where page 73, first paragraph, Mr.
No, my lord, order dated 3rd of May.
Yes.
Then, my lord, first paragraph, Mr. Ganguly state.
Third paragraph. No. Report shall also indicate.
The report.
So you did not approach the Chief Secretary for sanction.
Lordship, we approached.
You are for CBI, na?
Yes, Lordship. We approached in the month of September 2022.
That is on record.
Yes, Lordship. Order from the earlier
September
22.
22. The first letter was initiated. Approached.
Of 22nd September 2020.
No, Lordship. September 2020. I know the exact date. We have.
In September 2020.
The month of September 2000. 30th of September 2022. We first approach. And there
2.5 months, 2.5 years back. 2 years,
11 to 12 letters.
3 months back.
But my lord will also kindly see two things. Page 64, your lordship will kindly see.
It's 64 hours in the counter watch.
When this issue with regard to sanction was first taken up by this honorable court on the 22nd of March 2024.
Yes.
According to them, they wait from September 2022 till 22nd of March 2024, when even before this honorable court, they did not raise that issue. We had raised the issue that due to absence of sanction, cognizance cannot be taken. Then the issue was taken up by this honorable court.
So this order of 22nd March and onwards, these were also on these bail applications?
Yes.
Yes.
Then your lordship will kindly see page 75.
Yes.
But kindly see is order dated 3rd of July 2024. Read order dated May 7, 2024. A coordinate bench has directed the Chief Secretary to submit his response to the report filed by CBI as well as the proposal for sanction by the adjourned date. The matter was adjourned till June 11th, 2024. Thereafter, the matter was not taken up for hearing till date. Today, the state says there may have been some communication gap. Chief Secretary's response is not ready. We grant 3 weeks time peremptorily to the Chief Secretary to submit his response to CBI's report as well as the proposal for sanction to prosecute. In so far as this aspect of the matter is concerned, the matter will be listed 3 weeks hence.
Then that's the
Then,
next part, the more important.
however,
Yeah.
we are of the view
Issue of sanction to prosecute may not have any bearing.
Bearing on the bail application.
so on that the two were bifurcated. Different dates were given.
No, I
So
didn't follow.
this order on the 3rd.
Different dates were given for.
Yes, because this filing of the report
Oh,
was
you were
listed
saying this was
3 weeks.
bifurcated.
3 weeks.
And the
and
bail
in
on
this-
July.
And this was fixed on the 12th of July. So after 9 days.
The bail matter.
Then what happened? Then
Well,
it proceeded.
in that aspect, we were not parties. We are in the bail application with regard to whether the sanction would be granted or the pursuing of the Chief Secretary, that the CBI perhaps will be able to
Give an
better
answer. An
appraise
answer.
your lordship. I don't think the CBI also did not pursue that matter on that aspect also before the bench.
Because they never mentioned it before.
Yes. Then what judgments you are, Mr.
Well, we'll
Mukherjee?
come back on Monday and give it to your lordships, 2 p.m.
I can share one thing because from tomorrow 2 p.m. my brother won't be there. So
Tomorrow,
and
Friday evening.
my other brother is in circuit.
Oh, yes.
So-
No, but
so-
Mr. Dhiraj Trivedi is not there. He's not there. He'll be back on Monday.
I was asking if you can conclude tomorrow with the subject to your subject. I won't say that I'm saying anything.
That will have to sit.
No, but I have
get your lordship.
let you know that I am tomorrow.
Free. Your lordship is free tomorrow.
Can it be on a date convenient to a lordship in the next week?
Oh, to my lord.
If you people are not ready, then I will not take it up because I want to finish. it.
Yes, sir. We also want it, my lord.
Well, we'll have to sit together with regard to the place.
I understand.
That
That
is
is why
what
I
few of us
said.
has to
That
say.
is why I said that whether it is possible tomorrow or not. I cannot force upon me that come tomorrow and
that way your lordship will
never tell us, my lord. Your lordship is too good a human being.
usually do not do so because you have your own commitments and others.
Trivedi naile hobe na.
No, where see Mr.
He's gone to
Mr. Dwivedi when he is
Monday we will. He is returning tomorrow.
No, next Thursday.
অত করো না, অত করো না, অত দেরি।
you have to
No, ভুলে যাবে সব।
made their argument.
Tuesday.
Well, Tuesday if possible, my lord. Well, if it can be at 3 or 3:30, if it suits your lordships. Because it's just a question of giving your lordship the judgments, my lord. Because Justice Apurva Sinha Roy.
Mr. Mukherjee, do you want me to take on further documents for the purpose of concluding your argument?
No, only the decisions.
Only the decisions, my lord. Both the judgments rather.
একটা জাজমেন্ট বলেছেন সুপ্রিম কোর্টের, সেটা ভালো নয়।
Fix on next day you can conclude your arguments.
Yes, Lordship. Yes. We may conclude in a day.
My lord.
We have extensively heard Mr. Basu, learned senior counsel, or Mr. we are then taking up all the matters together, because all the
Yes.
ওইটা একটাতেই order